शुरू करते हैं। So, God bless you and your heart. Yeah. Good. So glad. Difficult situation happened. Thank you for coming. No, I think friends, shall we start? So, good afternoon, friends. So, on behalf of the Constitutional Conduct Group, it is a great pleasure and privilege to welcome all of you here this afternoon. And despite the small numbers, I'm told that we have a small group of friends also on the Zoom. And of course, there will be a YouTube posting. This is an extremely topical subject, and we're all, of course, breathing the Delhi air, so all of us know it. But I'd like to just give a brief capsule. The CCG, of course, as you know, started around 2017, and we are a loose group of ex-civil servants of different All India services. We have no address, we have no bank account, we have no office, and I think that's why we're still alive. But there's still a lot of commitment and a lot of hard work by a few stalwarts here. And we have a full slate this afternoon. So I would all request the speakers to keep to time. We have allotted about 18 minutes. I know it's very specific per speaker. And we will have 15 minutes after each session for interaction, question, answers, and so on. I'd also like to say that though the numbers are small and though the topic is very specific, the object behind a conclave like this is not just to educate ourselves on the issues, but also to create a kind of living community of people who are interested in these issues, so that we also form a kind of resource group and form a kind of sort of, what should I say, living think tank, so that we do have amongst our own cohort a group we can refer to and work with and discuss certain issues that are affecting us all. The convener of the first session is Prakriti Srivastava. She is really the person who's put this together. She's a retired officer of the 1990 batch. So without further ado, I'd like to invite Prakriti, and Prakriti can convene the first session. Thank you.
Thank you, ma'am. And good evening, everyone here. First, I'd like to invite our first session speakers to the stage. Please do come over, Mr. Ritvik Datta, Mr. Prashanto Sen, Mr. Prashant Bhushan, and Shivani, Ms. Shivani Ghosh. Please do come over. So welcome, everyone. I'd just like to give a small introduction, first of all, to the first session and what are the topics that we'll be covering, and also tell you what important speakers we have who have such domain knowledge and who have worked so much in this particular field. So to just introduce the first session, I'd like to say that the forests and wildlife and our environment have been given importance and protection by our Constitution, considering its essentiality to life and human welfare. Laws on forests, wildlife, and environment have therefore been framed so as to conserve and protect them. Therefore, any activity that will impact and degrade our environment, divert our forests, and negatively impact wildlife and their habitats are governed by a framework of laws that scrutinizes each such proposal scientifically and through a series of committees comprising of experts and representatives having domain knowledge. Forest clearance is a government approval process for diverting forests to non-forest purposes, such as for projects like roads, mines, and infrastructure. It is a legal requirement under the Forest Conservation Act, which mandates that prior approval be obtained from the central government before any forest land can be used for purposes other than forestry. The same is the case for wildlife clearances, and such clearances are mandatory permissions required for any project that impacts areas designated for wildlife protection, such as national parks, wildlife sanctuaries, or tiger reserves. And environmental clearances are also mandatory regulatory processes in India that assess and approve projects like industries and infrastructure before they start to ensure that they don't harm the environment. While we have ideals that are very lofty, how are these laws actually being implemented? So today we have experts who will throw light on its actual functioning, especially in the background of the Forest Conservation Amendment Act of 2023 and the landmark Supreme Court order in writ petition 202/96, commonly called the Godavarman order. Our panel of speakers have expertise on the topic, and they will be speaking on, and we will be educated and enriched by their insights. So let me introduce our speaker. Our first speaker will be Mr. Ritvik Datta, who will be speaking on diversion of forests, wildlife habitats, and role of the Forest Advisory Committee and the Standing Committee National Board of Wildlife. Mr. Ritvik Datta has made a reputation of fighting fiercely for conservation and obtained many positive outcomes for conservation. He is the founder of LIFE and currently heads the organization as the managing trustee. He graduated in sociology and law from the University of Delhi and has been involved in environmental litigation for the last 20 years. He is presently involved in litigation in the National Tribunal, Green Tribunal, the Principal Bench, as well as the environment benches on subjects related to challenges to environment and forest clearance. He is an Ashoka Fellow and recipient of many prestigious awards. Our second speaker will be Mr. Prashanto Sen, who will speak on Forest Conservation Amendment Act 2023 and its conservation implications. Mr. Sen is a senior advocate practicing in broad range of commercial, regulatory, and public law disputes. He is frequently involved in high-end commercial, environment, mining, energy, and infrastructure disputes. He appears in the Supreme Court of India and the High Courts of India, as also before the National Company Law Appellate Tribunal, the National Company Law Tribunal, and Appellate Tribunal for Electricity. He has also tried to balance his commercial work with matters of public importance and has taken up important issues of nature and conservation, taking up cases of the Great Indian Bustard and the challenge to the Forest Conservation Amendment Act, obtaining many positive orders. Our third speaker will be Mr. Prashant Bhushan, who will be speaking on environment clearances and the Environment Advisory Committee. He is an author of many critically acclaimed books and a public interest lawyer in the Supreme Court of India. His main area of interest has been human rights, environmental protection, and accountability of public servants. He is associated with various organizations, including the Center for Public Interest Litigation, People's Union for Civil Liberties, and Transparency International. He is also the convener of the Working Committee of the Campaign for Judicial Accountability and Judicial Reforms. Ms. Shibani Ghosh, our last speaker in this session, will be speaking on the Forest Conservation Act and its correlation to the Godavarman order and its relevance today. She is an advocate on record in the Supreme Court of India. She writes on issues relating to environmental law, regulation, and governance. She has authored several articles, book chapters, and opinion pieces on environmental issues. As a practicing lawyer, Shibani appears in cases before the Supreme Court of India and the National Green Tribunal. She has also been a Sustainability Science Fellow at the Harvard Kennedy School. Shibani also studied at the University of Oxford as a Rhodes Scholar. She appears in many cases pertaining to the Godavarman order and has deep insights on it. We look forward to the talks and a question-answer session at the end of this session after our distinguished speakers have shared their insights and views. Thank you. I now request Mr. Ritvik Datta to please address.
Thank you. Firstly, for inviting me and the opportunity to share some of my insights. The other speakers who have far greater experience in this field, especially Prashant Bhushan sir, who's here. But what I will try to do, I've been requested also to little bit give a brief intro to the process itself. So I think on the environment part, Godavarman part, a lot of them will be spoken. I'll try to give what is my perspective about it. I would look at basically how two institutions is not easy to be within time, but I'll try my best to condense it within this limited time. So what I will be looking at next, please, is the fact that the foundation of this is Parivesh. Everything related to environment clearance goes into what we call as Parivesh. It has nothing to do with environment. Interestingly, it's a short form of proactive and responsive facilitation by interactive, virtuous environmental single window hub. Now, I don't know whether the acronym comes first or the one comes, but it is called Parivesh. It has no word called greenery, green, anything. So for everything, the answer is Parivesh 1.0 and Parivesh 2.0. It's very confusing. It's not so easy, but whatever I could make sense of. So what really happens is you take EC, environment clearance, FC, forest clearance, WL, wildlife clearance, and then CRZ. I'll be concentrating on FC and WL, which is the wildlife clearance. Next. So we have the National Board for Wildlife, which is headed by the Prime Minister. It has met now once in the last 10 years. Right, and that was after a lot of pressure, hardly for about an hour, I think, or less, in Gir. There is a standing committee of the National Board for Wildlife, so almost every power is exercised by the standing committee of the National Board for Wildlife, which is headed by the Environment Minister. There is, which I will come to later, is the Forest Advisory Committee, FAC, which is headed by the Director General and Special Secretary in the Ministry of Environment and Forest. We have a State Board for Wildlife, which is headed by the Chief Minister. And now we have, based on the amendment that has taken place, the Standing Committee of the State Board for Wildlife. Next, please. So I have, looking at all the clearances, the judicial decisions, I can basically state that if you look at the way the FAC and the Standing Committee, I'll not say National Board because it practically doesn't exist. It can be basically put into the decisions broadly can come into about 6 of the broad categories. One is illegality. Second is acting under dictation. The board actually doesn't exercise much power. They act under dictations of an unknown power there. There is clear instance of non-application of mind. The whole process, I'll try to show with some examples, is of one which can be termed as empty formality. The approach is what I can term as rubber stamp approach, and the speed with which this authority functions, all of them. It's amazing. And they actually came out with, I have not put it in the slide, it was called the Star Rating Program. It got quashed by the National Green Tribunal this year. It basically says that authorities, especially state impact assessment authorities, will be marked and given stars based on the speed with which they get clearance. So they'll be given 0 marks if the members ask questions. They'll be given 0 marks if they do site visit. The highest marks happens if you do all the discussions and decision. within the meeting room itself. So let's go to the first ones, please. Next so this is just to give you a background, because I was requested just to. This is the Forest Advisory Committee. This is where, and here there is a provision for non-official members, which earlier were experts or civil society members. Sorry for saying this in the crowd, but what has today happened is a non-official member usually is a retired official. It defeats a lot of it. So here we have a situation where all bodies which have non-officials are retired officers themselves. There's hardly any voice of either experts or civil society. I'll leave that out. But this is where we have the Forest Advisory Committee. Next is the Standing Committee of the National Board for Wildlife. I've already said. Here also, if you see, it's interesting. There is a nominee of the Gir Foundation. It is put in the category of a civil society group, but is actually the CEO is a serving forest officer, and it is headed by the Chief Minister of Gujarat. So I don't know how it figures as a civil society group. Leaving that aside, we come to next. And what is interesting here is the law says that the National Board for Wildlife shall constitute the standing committee. Here it's the other way around. The standing committee itself seems to constitute the national board. The national board the standing committee was constituted in this one, 22nd July 2014. The composition has remained unchanged. This is perhaps the only body which has remained constant over the last 1 decade. And this is how it functions. And I'll give you some examples here. Next, please. So what comes to the National Board for Wildlife is what we call as protected areas and eco-sensitive zones. My focus is on the protected area. If you see here, the definition of protected area includes national park, sanctuary, conservation reserve, and community reserves. Next. Now, the heart and soul of why we call an area as a protected area is you are not supposed to do any activity unless that activity is for the benefit of wildlife. That's the heart and soul of section 29. Destruction and removal of wildlife or change in the flow of water outside the sanctuary, this same provision is also for national park, is permissible only if such activity is for the better management and conservation of wildlife. So when a proposal has to go in, the only ground on which it can be approved is that it must benefit wildlife. But over the last decade and a half, not one, not two, not three, hundreds of projects have been approved which do not benefit wildlife, or on the other hand is directly destructive to wildlife and its habitat. And so therefore section 29 seems to have been forgotten in almost 90% of the proceedings of the Standing Committee of the National Board for Wildlife. Next. So if you look at it, what is an implication? We call about roughly between 3 to 4% effective area as protected area, so that wildlife can thrive in these areas. The law says a protected area, whether it's a national park and sanctuary, no denotification is permissible. The law is clear. Denotification is not permissible in a protected area. It cannot. Tiger reserve, yes, in public interest, but not, and tiger reserve is not a protected area. So therefore, no denotification is allowed. No destruction of wildlife and its habitat is allowed unless it is for the benefit of wildlife. Only NBWL has power to allow under 25 if it is for the benefit of wildlife. Next, please. Now, if you see, I'll just give one example. I'm not getting into too many because I know there was a joint letter by, if I'm not wrong, by this group on Andamans. Galathea Bay Wildlife Sanctuary. The entire sanctuary was denotified by the Standing Committee of National Board for Wildlife without there being any provision in law for denotification. They denotified the entire sanctuary. So the question was asked in Parliament, right? It's a very interesting question. Whether the denotification of Galathea Bay is beneficial for ecology and marine turtles. Look at the answer given. After denotification of this sanctuary, Andaman Nicobar administration was directed for a comprehensive management plan to be prepared and other relevant, and followed for conservation and protection of leatherback turtles in Great Nicobar Islands. So we denotify it. Now you come with a management plan to look into. You could have done that without the notification. So here is one instance where not one, we have centuries after centuries been denotified in the country, vanished through the standing committee without there being any authority of law. Next. Now, if you look here, this is the recent proposal, Karnataka. A huge pump storage plant coming up in the Liontail Macaque Sanctuary, approved by the standing use of 42 hectares of forest land in the Sharavati Valley Liontail Macaque Sanctuary for the Sharavati pump storage plant. And if you see, this is the 9 July one. Next, please. And if you see here, it has been recommended for approval. Now, if I come here, after in the interest of time, I'm not going. We just looked at the number of approvals given by the National, the Forest Advisory Committee. I come to the Forest Advisory Committee. It's an interesting body again. Number of projects this, and we always say, well, Ministry of Environment is a hurdle and all. Look at between 24 and 24 data. We have looked at only Parivesh 2.0, not 1. It meets every month. Roughly about between 40-45 projects, 20 to 25 projects are considered. Next. And only 2 projects have been rejected. They were not rejected, they were sent back because of incompleteness of the information concerned. So what I calculated there, the rough amount comes to about 115 acres of land per day is legally diverted by the Forest Advisory Committee at the central level. 40 hectares and below are going to the regional one, and bulk of projects are today 39 hectares because they go to the regional empowered committee and get an approval. So what we have is roughly between my estimate is about 300 acres of forest is legally diverted under the provision of Forest Conservation Act. Therefore, I personally consider Forest Conservation Act as a Forest Clearance Act. The ministry has a division called Forest Conservation Division. Many of you would be aware. The Forest Conservation Division of the Ministry of Environment only works to divert forest land. There is no second work of the Forest Conservation Division. I met the IG, I know them personally. They said, मेरा एक ही काम है कटना. जंगल सुबह से शाम कितना कटना है, वो मेरा एक ही काम है. So therefore, if you look at this is the approved one. Next. I'm trying to be. Now, this is very interesting. There's not one, so many of you would be aware. Supreme Court has said, and many judgments are that if the law requires you to give reasons. Now, FAC, forest diversion, follows a process. It goes to the DFO, it goes to the CF, it goes to the CCF, it then goes to the PCCF. At every stage, an officer has to write reasons why they are allowing the diversion of forest. They have to give reasons. The law requires them to give reasons. The principle is, even if the law doesn't require to give reasons, you have to give reasons. Now, there is a detailed form. Now, here, in many judgments, they said in Income Tax Act and all, rubber stamp reasons cannot be considered as reason. You cannot just say, I am satisfied, I recommend. That is not what is there. These are tax matters under reassessment proceeding, where I said you have to give detailed reasons. When we talk of forest, it's a million-year creation. You must give reasons why you think it's important or necessary to divert it. I'm giving you an example. This is just few examples. There are too many of it. I don't want to take too much time. Next. Now look at it here. Dembe hydroelectric project in Arunachal. This is how the process works. It's a diversion of forest land for a hydropower project. Next. The question asked is whether any rare, endangered and unique species of flora and fauna is found in this area. Answer given is no. Right? And you look above. The nearest protected area, Kamlang White Sanctuary, is at a distance of 50 meters. Right? All project components are located within 50 meters from the tip of the proposed reservoir. Next. The same officer now here, when it goes to the PC's nodal officer, APCCF, detailed opinion and recommendation of the forest department. The detailed opinion is recommended for acceptance. Next. Now, this is very interesting. This is a recent case of in Ahmedabad, in Gujarat, where detailed opinion is recommended for sanction. But what is interesting is next. The courts have said rubber stamp reason cannot be regarded as a reason. Next. The state of Gujarat actually has printed and made a rubber stamp for recommended now. State next. Can we see? This is Rajasthan, another state. They've actually prepared a rubber stamp for recommended. Now look at the question asked. Detailed opinion and specific recommendation of the State Forest Department. Nil. We just want to put recommended. I am tempted to ask, is there a rubber stamp for rejected? I doubt it. Next. Now this is again interesting. This is a standard response in 90% of the approval. Question asked is whether any rare endangered species of flora and fauna are found in the area. Please see the answer. This is regarding Kana Pench. Please, next, last, can we go back? No rare, endangered and unique species of flora and fauna are found at the time of inspection. I go at 12 o'clock in the afternoon. For 2 minutes, I don't see any tiger. I come back and write nothing. Based on this document, the project gets approved. And then when you go to a court, he said, well, officers have looked at it. They're experts. We are not experts. We cannot substitute the view of experts for our view. Yes, I'll just finish. Next. Then if you look at it, this is another one. This is interesting. It's a Shahpura one in Shabad Conservation Reserve in Rajasthan. The High Court is looking into it. But just to say here, this is the documents given by the project proponent. They said we could not locate any other place because all the others are in protected area. Next. They say it does not form part of any wildlife sanctuary, biosphere reserve, tiger reserve. 1.17 lakh trees are to be cut. This is a statement given. Next. Proposal for diversion. After careful consideration, it is granted. While granting the clearance, they find out that actually it's part of a conservation reserve. Shabad Conservation Reserve. So what happens next page is the proposed area is part of a conservation reserve. Therefore, you come out with a wildlife management. So conservation reserve has no value, sanctuary has no value. If it is a national park, denotify it. What is going to remain? Can I just take 2 minutes more and just speed? If you want to look at speed, look at the recent one with regard to Sariska. There's a plan to denotify. How it happened, in the interest of time, I'll just give you a few dates. Next. On 23rd, there was a meeting of the State Board for Wildlife. It approved the decision of the Standing Committee. On next day, decision of SBWL was uploaded on Parivesh website on the 24th. On the 25th, the NTCA has a meeting and it recommended and accepted the SBWL's approval. On 25th itself, so 24th SBWL decision, 25th NTCA, National Tiger Conservation Authority meets, 25th it is uploaded. And on 26th, the National Board meets and clears the proposal. It's in 3 to 4 days, it moves from the level of the Forest Minister right to the Environment Minister, and the minutes are up, the agenda is uploaded at 2 o'clock at night as per news reports. I'll skip some of them in the interest and just come to the last. Just next, we can leave this out. This is one instance where, only to give you one aspect, that why I'm saying acting under dictation. Secretary MOEF recently, as per NBWL meeting, says what is going to be tiger corridors, NTCA will have to limit it only to what is called least cost option. You cannot take it to any other one. So NBWL dictates to NTCA what corridors should be. Next. I'll leave this out. Please, next. And this is one, it came out, I'll end with this 3 slides only. There was a massive public outcry because when Prashanto was doing this matter on this, it came out that they had diverted 8,500 hectares of forest land when the matter was in the Supreme Court, right? And it came in, it led to a question in Parliament. Next. And this question by Harish Biran, who happened to be at one time MOF's counsel, whether it's the fact that the government has approved 8,500 hectares. Media was wrong. Answer of the government is, during the period, 12,000 hectares of forest land was diverted. Now, this is where the issue comes in. I end. There's a sense of pride कि आज एक अच्छा काम किया है, जंगल साफ किया है. आप 8,000 बोल रहे हैं, हमने 12,000 किया. हम लोग मेहनत कर रहे हैं. Right. So therefore, they've actually done 12,500. So your information is wrong, as always, media is wrong. I end with just two final slides here. The country that actually recognized, next, is, we'll leave it next, please. Next. Ecuador was the first country in the world to recognize the rights of nature. Right. And I hope India does not follow on Ecuador's footsteps. It puts the rights of nature in the constitution. In 2008, it became the first. It was elaborated in 2015, and it's the shining example of what right to nature will be. Next slide. Ecuador this year took a very interesting decision. They abolished the Environment Ministry and merged it with the Ministry of Mines and Energy. I hope we don't follow that. Thank you.
Thank you so much, Mr. Ritwik. It was really enlightening and in a very negative way, entertaining also. So thank you. And I request our next speaker, please do come.
Very good afternoon to everyone. First of all, it's a great honor to address this esteemed audience, because I myself have been brought up by two civil servants, and that is my parents, and I have grown up hearing my parents speaking about many of you with great admiration, and therefore, for me, I was extremely excited that I had been called to participate in this discussion. And I think people in the audience and in the group are people who I've looked up to in the growing years, and my admiration has increased because post-retirement also, they have continued to be very important opposition to the corroding of institutions because of anti-democratic practices. Now, when looking at the conservation aspects, I think Prakriti ma'am, who's sitting here, is far, far more equipped than me to be able to point out what the aspects were. In fact, she was the one who gave all the provisions and all, and we were just spokesman. Of course, we had to modulate how we want to put it across. That's our expertise. But there was this combination. But having said that, I'd like to, when we look at the conservation aspects, I'd like to look at it in three parts. The first would be, of course, to look at the provisions itself, some of the provisions which have pernicious conservation impact. The second would be the manner in which the Supreme Court looks at those provisions or can be persuaded to interpret those provisions in order to give effect to the act. And the third would be the manner in which the provisions are enforced through court orders and executive implementation of the order. So because conservation is not just, act is not just this aspect, but the aspect of implementation and the way they are looked at in courts. And in that, I think it's very important, as ma'am was just saying in the beginning, that this group is to be a think tank. It's of experienced people. We have to look at strategies on how to best maximize one's effect in the interventions which we make. So first is, of course, as the original legislation says, that the Forest Conservation Act of 1980 was enacted to not allow diversion of forests without central government approval of above a certain area. And that did have a positive impact. There was increase in forest area. It was not like what the picture right now, which entertaining but gloomy picture put forward by Ritwik. So it did. And in fact, the Supreme Court gave a very wide definition to the forest also. It said irrespective of ownership, irrespective of the fact whether it is there in government records or not, if it is forest-like or like a dictionary meaning of forest, then it is entitled to protection. So that was a very positive development. But then comes this amendment. which was the objective was, and this is the typical double speak which an authoritarian state speaks in, it is that it was first of all renamed, all renamings take place. There's one Sanrakshan Evam Samvardhan Adhiniyam, which purports to streamline forest governance, meet national security needs, and fulfill India's international climate commitment. But if we look at the closer scrutiny of the provisions, the various provisions which are there, it is doing exactly the opposite. And that's the most entertaining part of it. The most significant attempt was to try and narrow the scope of the word forest to land which is either declared or notified as forest under the Indian Forest Act or any relevant law, or a land which was recorded in the government records as forest. So this is again, it was trying to kind of circumvent the Supreme Court decision on the Forest Act, and this weighed with the Supreme Court in giving us the interim relief initially. The adverse outcome would be as follows: that the amendment would exclude about 1.99 lakh square kilometers of deemed forest and unclassified forests that were till now protected under the expansive definition of the Supreme Court. This will leave the excluded areas vulnerable and the discretion of the government for diversion for commercial purpose. The other very glaring effects of the Act are the vague definitions of project and activities which enable them to be kept out of the purview of the Act. The Act, for example, excludes forest land along railway line or public road which provides access to a habitation or to a rail and roadside amenity. This will also apply to feeder road. The number of such feeder roads, the distance between the roads is not specified. This will enable large-scale destruction of forests because of this ambiguity which is there. It's left open to the wild discretion at the lower levels on how they want to take it forward. The Act also exempts plantation and deforested areas from the purview of Forest Conservation Act to incentivize plantation. However, there is no legal safeguard against the land being used for non-forest purpose. Land up to 10 hectares is exempt from scrutiny under the Act if it is being used for construction of security-related infrastructure. There is no clarity on what would be considered as security-related infrastructure. It's not only in civil rights issues where they say national interest, security. It's even in forests that they are using it to kind of undermine the whole institution. The Forest Conservation Act included a list of activities which are not to be considered as non-forest purpose and were permitted within forest land. This list provided in the explanation 2 included public works like establishment of checkposts, fire lines, etc. This was earlier the case. The amendment arbitrarily expands the list to include safari, zoos, and ecotourism activities. I mean, I don't need to dwell upon this too much with experienced people here to see how easily this can be distorted to create large tourist spots which have no regard for environment at all, except to the extent that it brings them the money in. Now, the other important aspect of this legislation was that there was no standing committee put in to look at such an important legislation when the legislative process is taking place. Instead, you had a joint parliamentary committee in which two false representations were made very blatantly by the MOEF. One was that they are not tinkering with the definition of the forest as interpreted by the Supreme Court. And that we kind of have pointed out to the Supreme Court also, and how by these definitions which I showed the way it's restricted, that it was clearly interfering with the definition. So that was the first false position. The second false position was that all the state committee expert reports, because earlier the Supreme Court, when it had expanded the definition of forest, had told all states to have expert committees in place, which will outline what are forest areas, and that would be on record. Those had not come in, but still the MOEF blatantly tells the Joint Parliamentary Committee that we have the reports. Now, it took the perseverance of someone like Prakriti ji and others to send in RTIs, find out from the MOEF where are the reports. They say we don't have it. So there was a blatant lie which was there, which we put before the court. And there is a slight issue here which we need to keep in mind. Usually the court does not strike down a statute on the ground that it is malified or what are its intents or what are its motives. And partly this procedure which was going on was pre-legislative. So there could be a way in which to try and think that you can get out of it. But I think where community forest resources are involved, there should be greater judicial scrutiny about the manner in which the act was passed. And there can be possibilities. There are precedents by which we can do it. And I think in this case, we are going to argue at the whenever we get a good opportunity to do it, that when community resources are involved, the manner in which it is passed is also important. And there are precedents by which we may be able to break through in that line in the jurisprudence. Now I come to the second part, which is advocacy involved in the act. That's the last mile. That becomes the important way in which actually if the act, whether if it's beneficial, how is it to be enforced? If it is pernicious, how is it to be prevented? So 2 or 3 things we did. First, it was a combination of civil society members, because now retired civil servants, who had domain knowledge, who could at a click of a button and through long hours of work provide information. And also how the institution is going to react to the information which we are going to put forward before the court. For us lawyers, of course, we were there with them, knowing that their integrity cannot be doubted, their objectives cannot be doubted, and that weighed with the court also. So the important thing with the CCG, I think, should understand, and important is, the court looks at people who have been in institutions to be very responsible, and being responsible while making the statement. It lends great weight to the petition as opposed to a normal PIL. That's the first point which was there. Second was that we took a strategic call. We applied our mind together. We said, even if the act has not come into force, though notified in a gazette, let's challenge it. Let's have a first mover, challenge it beginning. So we did that also. So that was a legal strategy which was involved. We had a good bench before which we came, and the bench in fact asked the ASG to give an undertaking that they will not dilute the definition in their practice. He gave that undertaking, and of course in a lighter vein. He was anyway wanting to leave, but I think 2-3 days later he resigned. Perhaps he was pressurized. I tend to speculate that perhaps he was pressurized and he took it as a good opportunity to leave. But that's on a lighter vein. It's not, I'm not saying that happened. But anyway, so that was the second part, that you had an act being challenged at the earlier. Then the coordination. Prashant was there, Gopal Shankar Narayanan was there. We all had a bit of a discussion to be able to coordinate and not make contradictory petitions with each other or submissions to each other, so that the court also gets confused and it becomes easier to do it. So the coordination in legal strategy was also very important. And then, as I pointed out, the domain knowledge and the identity of the petitioner, that made a big difference with the courts. And here I'd like to make one unsolicited suggestion. I think writing letters to the court may or may not work well. It can often, I think, it goes in, if you have already filed a petition, or if you are taking an action to court, take it through the court channels rather than letters, etc. Because that may, for many judges, they may react differently to it. So I feel that coming from institutions, since you have the institutional experience, this kind of a letter writing may not have much effect, may have an anti-effect. And I think that's, as far as the courts are concerned, may be avoided as far as possible. That is my personal view, unsolicited. Now, the other point to be kept in mind is that, which I wanted to come down to, is the enforcement of the orders. Now, that is the part which is a bit frustrating. We got some initial good orders. We got the Ashok Sharma order passed by Justice Chandrachud, and then we had an excellent order by Justice Gawai saying, which was from 1996, this issue was pending, not this thing. They said he should notice, and he said, if these expert committee reports do not come in by a certain date, I'm going to hold the chief secretaries personally responsible. So that was a great message which went out. But then thereafter, because of the overload, the court was not able to take up the cases on time. And in fact, it has enabled the government to keep moving forward. And we have filed certain applications. It's not to say that we didn't get a chance to get it on board, but then on the day it comes on the board, there are so many other cases. It doesn't come up. And as a result of that, what happens is that government moves forward. So they move certain rules in which they are saying, if the area is deforested, suppose an area is diverted for non-forest purpose, for compensatory afforestation, you will lose forest land for that purpose. So what happens is you divert a certain area, you use forest area itself for compensatory afforestation, so you're reducing the forest land which is coming. And that is something which we want to bring before the court, which unfortunately, although the applications are there, the research is there, we have not been able to do. So that is one thing which is the hard part here, which we have to look at. But as Tolstoy said, time and patience are the two great warriors. We have to somehow kind of endure, persevere, keep at it, and file our RTIs, put our applications on time. get that right opportunity also. There may be situations where we may not want to press an argument before a particular bench. We may decide to take a strategic call. Kind of have the trust on the lawyers on that for that to, take that call. But I think you all are well versed in that also. Perseverance and this thing. So I think it would succeed. So finally, I would like to just end by saying that I think interventions like these point out that although space is shrinking for NGOs, their FCRAs are being removed, etc. Although the space is shrinking otherwise for civil society to be able to dissent in any way, we still have a very important force, which is you all, in the institutional spaces of courts, etc., to collaborate with civil society and bring out, at least even if you don't get a positive order, discussions on those issues which come up in the courts. Which can then be taken forward, and I think that's a great service which one would do against mindless draconian measures which come about. Thank you very much. Thank you.
Thank you, Prashant sir, for such a good talk. And I must say that sir has represented the case in the court, and the type of orders we have got is due to his ability to present the scientific part, etc., in the court so forcefully in such a nice way that we got some 3 very good orders. So thank you for that also. So I'd like to invite our next speaker, Mr. Prashant Bhushan. Please do come.
Thank you, Prakriti. It's indeed a pleasure and an honor to be here before such an august gathering of such experienced people from civil society who have, many of whom I know have rendered yeoman service to public interest, to the cause of the environment in this country. When the Environment Protection Act came, at that time, there was a clear realization among those who in the government that the Environment Ministry needs to be a regulatory ministry, which needs to regulate the activities of all the other arms of the government in the interest of the environment. And therefore, there was a realization that there needs to be a separate independent cadre of experts and environmentalists within the Ministry of Environment itself. Initially, there were a substantial number of dedicated officers who were recruited directly by the Ministry of Environment and who spent their entire careers in the Ministry of Environment. But gradually, those people kept retiring, and gradually we had this system of people who floated in from other ministries. So an officer from the Ministry of Mines or the Ministry of Coal would come into the Ministry of Environment as Joint Secretary, etc. And eventually the decision makers within the Ministry of Environment largely came to be people who were not dedicated to the Ministry of Environment, but who were floating in from various other ministries and departments. And therefore, gradually, the regulatory or the independent regulatory role of the Ministry of Environment kept getting diluted. Now, the Environmental Appraisal Committee, which was created by the Ministry of Environment to appraise various kinds of projects which were above a certain size or which were likely to have a significant impact on the environment, etc. Again, it was supposed to have experts in the field of environment, but gradually what we have been seeing is that these experts are like, for example, the current composition of the Environment Appraisal Committee is one gentleman who was former member secretary of the Haryana State Pollution Control Board. He is the chairman. So these are people who have held some official positions. One other gentleman who was the former group general manager of ONGC. One other gentleman who is the professor of chemistry in some university, some obscure university in Tirupati. One other gentleman who is from the Department of Applied Geology in another university, and so on. So, one other gentleman who was the executive director of the HCL Corporation. These are the people who have come to man the Environmental Appraisal Committee and who are supposed to be environmental experts. As Ritvik said, if you see the Standing Committee of Wildlife, actually a very detailed study was done of the appraisals and approvals given by the Standing Committee of Wildlife. It was done by the National Law University along with Goa Foundation, National Law University in Hyderabad. And they found that the same thing which Ritvik told you, that approvals were being given for 25, 30 projects in one shot. Almost all the approvals that have been given are supposed to be in the interest of wildlife, but are clearly against the interest of wildlife, etc. Same thing has been happening with the Environment Appraisal Committee also of the Ministry of Environment. In fact, there is this very fine institution called the South Asian Network on Dams, Rivers and People, which does an annual appraisal of the functioning of the Ministry of Environment and the Environment Approval Committee. And their latest report on this reads as follows. If I might just read a few paragraphs, it says, a detailed review of functioning of the Union Ministry of Environment and Forests Environment Expert Appraisal Committee on River Valley projects for 2024 shows that the committee, or for that matter, Ministry of Environment, has almost non-existent rejection rate. Even when a project is not cleared, when it applies again, it gets clearance. Whether the application is for stage 1 or stage 2, even in some cases like pump storage projects in the Western Ghats or hydropower projects in disaster-prone Himalayas, including disaster-stricken projects like the Tista project in Sikkim, the scrutiny, including field visits by the Environment Appraisal Committee or subcommittees, is minimal, not worthy even calling it a scrutiny. Even in cases like the 1500 megawatt project in Western Ghats, where the project is asked to reapply due to massive increase in forest land, and when detailed letters are sent to Environment Appraisal Committee and Ministry of Environment about the impact of the project on community fish conservation areas, the EAC ignores its own concerns and no credible answers are available about the concerns expressed in the letter. We are asked to be satisfied that EAC is satisfied with the secret replies of the project proponents. Lack of transparency, independence, scrutiny, reasoned reports, lack of accountability, and non-existent credible scrutiny or rejection rate has been the signature characteristics of the Environment Appraisal Committee and MOEF, and 2024 is no different, even when faced by increasing, massive, and intense disasters affecting projects, people, and even rivers. So, why is this happening? The answer is very obvious if you understand how the present government is functioning. The present government is functioning on the diktats of those who are at the top, particularly the Prime Minister. Nothing else, no other institution, no civil servants, nobody matters. If anybody tries to get in the way, if anybody tries to raise any objection, for example, when Mr. Ashok Lavasa, when he was an election commissioner, when he just disagreed on whether the Prime Minister had violated the Model Code of Conduct, he was forced to resign. His wife was hounded and he was forced to resign. Everybody in the Ministry of Environment or Environmental Appraisal Committee knows by now that, look, if you try and object even a little bit to any project which the government wants to go ahead, and of course the government is totally in the hands of its cronies, and therefore environment, forests, etc., wildlife is of absolute zero concern to this government. Zero concern to the Prime Minister, absolutely not even an iota of concern. Therefore, everything exists for the industry, for their own cronies, and therefore, whatever the Prime Minister wants or whatever his cronies want, that writ runs. And that is understood very well, extremely well, by all those who are put on such bodies like the Standing Committee on Wildlife or this Environmental Appraisal Committee of the Ministry of Environment. Of course, by and large, there are only those people who are put, who are supposed and who are known to be yes men. But even if there is somebody who is kind of half independent, he knows that if he tries to object, he will be removed from the committee forthwith. There will be. To give you some examples, Ritvik was mentioning Ecuador and that there the Ministry of Environment has been merged with the Ministry of Mines. Actually, it has happened in India also. Not nominally yet, but in actual fact, it has happened. So there is this case that we are doing regarding, we are saying that the Supreme Court imposed a cap on iron ore mining in Goa, in Karnataka, but there is no cap in Odisha where the maximum iron ore mining is going on, and therefore there needs to be a cap in Odisha. The mining is doing two things. It is causing enormous devastation to the environment there, and secondly, it is also so. The Odisha government had said that their reserves are such that at the present rate of mining, they will not even last for 20 years. So there is this problem of intergenerational equity. So on our petition for this cap, the government was asked to file its reply. Now there were two separate ministries which were impleaded, the Ministry of Mines as well as the Ministry of Environment. The Ministry of Mines and Environment have filed a joint affidavit saying that there is no need for any cap, and in fact the reserves have increased by 4 times and therefore, or 3 times, and therefore it is not 20 years, that the reserves will last for 60 years. This is in sum and essence the stand of the Ministry of Environment along with the Ministry of Mines. Now, when in the Goa mining case, when the court imposed this cap on mining, they appointed the court appointed an expert committee. And in that expert committee, there were several people, and in that report, the expert committee, in fact, pointed out that, look, this is this mining which is going on is affecting so many aspects of environment, health, water, air, everything. They mentioned about 20 different aspects which this mining was affecting, and therefore on consideration of all those things they recommended a cap. Here the Ministry of Environment is asked to file a reply to our petition for a cap, in which we point out that the Center for Science and Environment had done a study of the iron ore mining going on in Odisha, which had said that it is causing all kinds of devastation, affecting the lives and livelihoods, the health, etc. of the people there, and so on. No mention of that at all. It's dismissed in one line saying that that's an old report. But no discussion whatsoever in the affidavit on any environmental aspect, and they just say, well, our reserves are good enough for 60 years, therefore there doesn't need to be a cap. And this is a joint affidavit, as I said, of the Ministry of Mines and the Ministry of Environment. So in that sense, de facto, there is already a merger of the two ministries. Long ago, in a judgment of the Supreme Court in the Lafarge mining case, the Supreme Court had said that we need an independent environmental regulator. They became conscious of the fact that the Ministry of Environment, which was formed, initially the conception of the Ministry of Environment was that it would be a kind of independent regulator. But gradually, with the erosion of the independence of the Ministry of Environment, and of course today there is zero, when it ceased to function as an independent regulator, the Supreme Court said that the government needs to set up an independent environmental regulator. But it's been now, that was a judgment of 2011, 14 years, finishing. 14 years down the line, there is no sign of the government appointing any independent regulator. Of course, even if the government were to appoint an independent regulator, they will appoint the same kind of people. So therefore, in fact, this election commissioner's case, the Supreme Court held that the independence is not merely secured by the fact that the government has no disciplinary control over the election commission. It is also necessary that the government does not control the appointments. So if this independent regulator is going to be appointed by the government, we are going to have the same kind of problem that we are seeing with the election commission in this country. So therefore, we need an independent environmental regulator. We need the appointment of that regulator to be secured by an independent appointing committee, which should have some people like the Chief Justice, etc. Of course, today the independence of the Supreme Court is also under a cloud. All institutions, the independence of all institutions are under a cloud, but still to the extent that is possible, we need to have relatively more independent people like the Chief Justice, etc., involved in the selection of the environmental regulator, and then only we will be able to get some traction on this problem of environment. Of course, we all know that with climate change, the problems of environment are getting exacerbated. This collapse of the Char Dham highways during monsoons, etc., is also because of climate change. It's also because of fresh cutting. I mean, both factors come into play. One is the fresh cutting of steep mountainous slopes, the dumping of muck into the river. And the second is that with climate change, we are witnessing higher rainfall, we are witnessing higher incidence of cloudbursts, etc. And therefore, all that is adding up to this problem. But this government is going on as if environment doesn't matter at all and we need to bash on regardless. This is the attitude of the government. So thank you very much.
Thank you so much, sir, for your very insightful talk and discussion about the sorry state of affairs. So now I'll invite Ms. Shivani Ghosh to come and speak to us.
Thank you so much, Prakriti ma'am, and thank you so much for inviting me. It's a real honor to be speaking at this event among such a gathering, but also for me, all my seniors on the dais. So it's quite a privilege to be coming at the end and having most of my points taken away by them, but spoken much more eloquently than I could have possibly done. But I also realize in the interest of time, perhaps it's all the well that I don't have as much time left, but I'll make a few points. So what I was asked to speak on was on the Godavarman order, the land, we think it's a landmark order of 12 December 1996, which really changed the definition of what forest is and what should be regulated under the Forest Conservation Act, but also what its current relevance is in terms of the Godavarman judgment, but also in terms of how we understand the Forest Conservation Act. And of course, Prashanta sir has already told us about the amendments and the ongoing case in the Supreme Court, which many people in the audience have been so kind to join and support in so many ways. And I've had the privilege of being part of the team who is working on this case. So I thought maybe give it a little bit a different point of view. I mean, I don't think there's any point in discussing exactly the words of the order of what it means, but I thought just working in the courts, what it means for us as lawyers, what does the Godavarman case mean for us? As you probably know, it's one of the longest running public interest litigations now, starting in 1995, and it's called this, omnibus umbrella forest case. For those of the lawyers who are not in the environmental fraternity, they're like, hey, Bhagwan, ye forest case kab khatam hoga? So, they just think this forest case is this long running hawa that's going on in the courts. And whenever it comes up in the court, it just takes up the whole time of the Chief Justice and all you environmental lawyers wasting all the precious time of all of us, rest of us who want to, really do the real law. So they're like, how much time will you take? How much time will you take? I'm like, there's a lot to talk. But anyway, so apart from that, I thought I'll just highlight a few issues that come up in the Godavarman case as an omnibus petition. It really isn't one petition anymore. It's so many issues that come up, which all relate to many, many different parts of the country, relate to different sanctuaries, national parks, tiger reserves. It could be one big issue that affects many states. It could be a tiny part of one district in one state. So each case is actually a case in itself, but in the eyes of Godavarman, it's what we call an application, and it makes it sound so small, but it's so significant that it's unfortunate how the significance of each of these small applications is lost. But altogether, if someone ever did kind of an impact assessment, not in the way it's done by the ministry, but if it was ever done, I think it would be a colossal job, first of all, but it would really show what a difference the case has made. Of course, many of the judgments and outcomes of some of these applications are not what would be called environmentally positive or in favor of the environment or environmentally benign. But keeping that aside, there are some judgments, some of the precedents, some of the positions of law that have been laid down in these orders and judgments in the Godavarman case, which definitely push the envelope on environmental jurisprudence in India on the whole. I think I wanted to kind of highlight three specific issues. And one of them, in fact, was highlighted by one of the speakers before me, is who is coming to the court under the Godavarman case. I mean, who are the applicants? Who are the petitioners who are really coming and asking the court for relief? Of course, now in recent past, we are seeing many of the retired government officers who are now coming, but that apart, and many of you are in the room. I think, my co-panelists today here have much more depth of experience and they could speak to it. The nature or the type of applicants who are now coming to court are very different, or at least is a much smaller pool than it used to be earlier. I mean, we see very few NGOs and civil society and advocacy groups that used to come much before, or environmental organizations which do splendid work on the ground. And we know they have fantastic networks and fantastic depth of research and experience and outreach. many of them don't come to court anymore. There are very few people who are willing to come to court and put their name to causes and issues. And we need people who have integrity, who can persevere, who have the time. We're not even talking about monetary resources, who just literally have the bandwidth to persevere and follow the case, which is really what we need as lawyers for our applicants to stand by us, because there's only so much as legal counsel that we can do. And unfortunately, that pool is increasingly reducing. And there could be many reasons for that. Amongst that there's a general fear about coming to court and calling out decisions of various regulatory agencies. Having said that, we still have people who are willing to put their name on that affidavit and put their name on the case and put their neck on the line. And I think that is very commendable, and we are grateful for those people to have come to court to bring out those very important issues. The second is in terms of how do these cases move? What is the bench? What is the kind of evidence that this bench is looking at? I mean, these are technical issues. I mean, these are environmental issues, but some of them actually break down to what the impact on a particular area of forest land is going to be, what's the impact going to be on air quality, water quality, soil conservation. Many of these things are technical, scientific, and I don't only mean, as you know, you need scientists, but you also need sociologists, you need impact on forest dwellers. There's so much of this which requires expertise, which is certainly not available within the courtroom, certainly not available with the legal fraternity. But what is it that kind of evidence, how is it that being presented to court? Who is presenting it to court? How is the court actually analyzing it, thinking about that evidence, then actually coming and deciding how is that evidence, if at all, influencing the court's final verdict, is something that's very interesting. And it's interesting how it's entirely unpredictable how it plays out if you look across several Godavarman orders. And of course, there is this Central Empowered Committee, which had been set up by the Supreme Court. It has been recently reconstituted. Membership of that committee has changed over time, and they are now former officers of the Forest Services who are now part of that committee. They are the ones who look at some of these cases on directions of the court, and they provide recommendations to the Supreme Court on how it should decide. Recommendations. They undertake site visits, they do hearings, they do meetings, they are supposed to meet all stakeholders, come to an expert conclusion, many of these issues, and then the recommendation goes to court, and then the court takes a final call. Now, how that entire process plays out, what kind of expertise goes in, what detailed assessment has been taken, who are the stakeholders, how much voice did they have, all of that is fairly ad hoc, occasionally non-transparent, very little accountability. And so that's kind of, unfortunately, something that plays an important role on how the Godavarman case plays out in court. The third thing is the role of the lawyers. As I said, our role is in some way limited, but in other ways perhaps not limited. Limited in the sense because we don't have the expertise that's required in some of these issues. But if we look at the role, for instance, of the amicus curiae, the amicus curiae has changed over time. It's a lawyer appointed by the Supreme Court to assist it. In the beginning, it were Mr. Harish Salve, Mr. Lalit, who later became the retired as the Chief Justice of India, Mr. Siddharth Chaudhary, Justice Narasimha, now Mr. Parmeshwar. We've had a range of lawyers who've assisted the court. Now, it's interesting what the role and the influence of these lawyers are on the bench. And it's hard to actually characterize it, but in court you can make out they play a very important role. Whether it is in a particular direction or not is for someone to decide when you're inside the court. But to have that one lawyer stand there and assist the court in such a significant manner, I think it's something for us to think about, is that why is the court looking at the Central Empowered Committee or at the amicus for such significant or such important recommendations or guidance, and what kind of role does that play in the final decision making? Finally, and I'll I think, well, 2 points. One point is, given the ambit of the Godavarman order and how it's expanded itself, there is a question about what the role of the high courts are, because a lot of the issues that come to the Supreme Court now under this Godavarman umbrella, I mean, I think there's a fair question to ask that why shouldn't these cases go to high courts, which are courts much closer to the place where the issue is arising. Perhaps the lawyers, for the applicants, it might be easier to approach those courts. They may have access to better legal counsel there. So I think there is that issue whether some of this should now be going to high courts if it's become just too big for the Supreme Court to handle. But I mean, that's something for courts to look, for there to have a discussion going forward. But I think what I want to end is, Mr. Prashant Bhushan Sir actually raised it towards the end of his presentation as well, is the issue of climate change. And I just, I think as an issue, and I'm hoping there's going to be we're going to talk about it in the second session a little bit more, but I don't think our courts are engaging with it at the level they possibly can and should, particularly on issues of forest conservation, habitat conservation, wildlife protection. I mean, all of these are so intricately linked and in a very complex fashion with the impact of climate change that a vulnerable country like India is going to face, and also actually exacerbate climate change in so many different ways, that I don't think our conversation, or at least in the Godavarman bench, the conversation, of course, there is the usual, thanks to Ranjit Singh Sir's judgment in 2024, Justice Chandrachud's judgment on the GIB. I think Ranjit Singh Sir will tell us more about it. But at least the judgment led to the recognition of this new right. So there is a conversation on rights and climate change. But in terms of a substantive engagement of what this whole forest conservation means, what decisions of diversion of forest land, several hundreds of square kilometers of forest land would mean when we live in a very real world where climate change is having, not future potential impacts, but impacts that we in cities are certainly feeling, people in the hills are certainly feeling, most parts of India are certainly feeling the frequency of weather events or extreme weather events. So I think that the relevance of Godavarman and the relevance of the Supreme Court and other courts while engaging with forest conservation certainly is going to increase as climate change becomes more and more part of our conversation. Prashant Bhushan Sir talked about how the Forest and Mines Ministry have now in fact, perhaps de facto merged in some cases. I was recently part of a case where it was before the National Green Tribunal and talking about Aravalis and how part of the Aravali has been notified as protected forest. But that same area has now been auctioned off by the Department of Mines. And so there's a case and the NGT has taken it up suo moto and, it's an ongoing litigation. So yesterday, as always, the government departments are taking their time to reply and respond to the case and, tell us what's going on. So the lawyer came up and we know him well. He said, my lords, we filed the Department of Forest ka affidavit aaj file ho gaya hai. So the judge is like, okay, good. Mining is the other one. मैं वो कल फाइल कर दूंगा. And so we're like, how are you, the lawyer representing the two departments which are clearly in conflict? But the conflict doesn't occur to the state that, you cannot have the two departments represented by the same counsel and who's confidently telling the court that, we'll file that I'll be filing or I'll be representing both the departments who are concerned and clearly in conflict. So we see that in courts, we see that outside courts, that environment is in a dire strait and we are very, there's so much to think about and consider, and I'm hoping that issues such as climate change, and I don't think that's the be-all and end-all of environmental issues, do really push us to think harder and talk about this much more going forward. And I'll end here. Thank you so much.
Thank you so much, Shivani, and for giving us an inside view of how the courts function, especially as far as the Godavarman order is concerned. I work very closely with her, and I think she's the future of advocacy in our country, especially as far as environment and forests are concerned. So thank you once again. And now I request that we may have a small question answer session. If anyone has any question, please do put it to the panel and they'll be able to answer.
You mentioned about the role of the amicus curiae, but you didn't give any illustrations about, is he in favor of the forest? Is he defending the forest? Or, what exactly ultimately is the role that he's playing?
Who are you addressing?
Shivani Ghosh.
Ma'am, technically, he's not supposed to hold the brief for either side. I mean, technically, he's supposed to assist the court to understand what are fairly complicated positions on fact and law. So the amicus is supposed to be a fair and independent overview of what the matter is. So I don't think we've had a she amicus in Godavarman, if I'm not mistaken. No, so far they are, so he's supposed to have an independent view and not take either view. But at least the current amicus, I have in some cases in which, in fact, I have been also in cases where he's seen, I've seen him vociferously argue on both sides, in different cases, if he sees the point in that sense. I mean, on the legal issue, he's not someone who is absolutely pro-environment just for being environmentalist, but he does take stands and he provides his his reasons and provides his kind of backing and logic and provides his notes and guidance to the court through that. But as you know, ma'am, I mean, technically he's not supposed to hold the brief for either side. But having said that, I mean, the whole Godavarman case was for protection of the environment. It wasn't. So the idea would be one would hope that the court would have a preference or a leaning towards an environmentally benign outcome. So one at least hopes for that. But it's hard to say whether that's happened in any predictable fashion.
There's an interesting shift in terms of wildlife that we are, currently seeing. We know that the Prime Minister has put his backing behind the cheetah project. We know the Vantara case, which of course was squashed in various ways. So, and there's also between states a certain competition to try and get animals to kind of onto their territory. So the lions from Gir to Madhya Pradesh or whatever. These are things that are going on. But how come the environmental base for animal life, which is of course the forests, how come that is being ignored in all this? And we know that in Vantara, for instance, they have all these artificial forests created just within the environs of an oil refinery. So you can see the strange, sort of clash that is happening there. So I don't know if anyone has any thoughts on this, but it's interesting to note this, that it's become a political issue. Thank you.
Everyone can answer, but I think if you see, there was an article published by the Environment Minister just 5 days back. It's titled "Breathing Life into Climate Talks." Right, and he loves to use the word life for whatever reason. But leaving that aside, what is important in all the messages that the Ministry of Environment is now saying, the emphasis is only on one: "Ek ped maa ke naam." एक पेड़ माँ के नाम. There is no discussion, conversation, or mention about forest. It is so if you look at it, forest is no longer a subject matter. It has been reduced to number of trees. The trees can be planted anywhere. You earn green credit by the planting. So therefore, locational aspect doesn't matter at all. You cut down in Andamans, you plant in Haryana, you cut down in Haryana, you plant wherever you want in the middle of the road. So the issue today is that in the discourse of the MOEF, it is all about trees. And therefore, it is something that the idea is it is very easily replaceable. It's very easily replaceable by planting 3 times the number of trees. So that's where the whole issue has come in. And I at least see it, at least when I see it, even with the Green Tribunal and others, the view is actually no longer on protection of forest as it exists. And I think that's the most difficult part. So today, as I was showing also, there's no sense of, I think shame is not the word, but the guilt that, I am doing something to destroy something created by nature. That is not there. There's a sense of pride in destroying. That's the
one thing I'd like to add about the cheetah project. Mr. Ranjit Singh is sitting here, who because of whom we had filed it. The government was initially against the cheetahs coming in. When we fought the matter, the Ministry of Environment and Forests vociferously opposed it, thinking that it will affect the Gir lion forests. Once it came in and the cheetahs were released on the Prime Minister's birthday, that was the only release which was allowed to be photographed. Mr. Ranjit Singh was there, others were there. No photographs were to be taken. Thereafter, I think it's become a question of bureaucratic sabotage, because then they wanted to, the bureaucrats in the current regime wanted to own that project. They cut off all expert advice coming in from abroad, from people who are far more experienced in being able to deal with it. We in between thought that, let's be a bit collaborative with the government. They will perhaps see reason and all, and it's not worked out. So we may consider another action. But I think it's just to keep proving to the Prime Minister that they are doing a great job. They ended up trying to do it themselves, and I think have botched up the project, which could otherwise have gone off very well.
So I'll make a brief comment and a question. The comment is that maybe we need to amend the definition of wildlife, because the way this government is acting, it's wilder than who we call the wildlife. And maybe they will actually do it because they're doing it for the benefit of the wildlife. The question is, recently there's been a report that about 1,500 leopards are to be moved to Vantara. Is that verified? And any comments on that, please?
I also read it. I don't have any. The problem, I think, is coming in where we have suddenly, found that the only place wild animals should be is in a forest. And that's the problem that has come in. So if you find nilgai on an agricultural land, it is a pest. If you find monkeys in the city, it's a pest. If you find dogs in a court and many institutions, it is a problem now. So what we have decided, we have created a Lakshman Rekha, where we suddenly say that if a leopard is in an agricultural land, it is outside its territory. If you look at the Wildlife Protection Act, there is nowhere mentioned that a wild animal should be found in a forest or in a protected area or in a national park. There is no correlation. 90% of our wildlife is outside protected areas. Your insects, your butterflies, your birds, where are they? So the notion that is there is very problematic here, where there's suddenly, and to be I will be honest about it, the forest department and the chief wildlife wardens of many states are also playing a very, very destructive role in this, in basically parroting whatever the ministers want to say. So you see leopard deaths and killing, the permissions increases whenever there's a panchayat elections. You give more and more permissions. So therefore, to your question, it is not that we know that it's certain, but it's a very disturbing trend of animals being caught or eliminated or killed. And if you see the demand in Maharashtra, they're saying, make leopard a Schedule 2 species. It's a danger. An animal that has survived in the human landscape is finding ways to survive in such a difficult condition. You are now going to kill it and moving. And moving and captivity is no different from killing the animal so far as conservation is concerned. Yeah, a day before, I think 3 days back, they captured a elephant within Kudremukh National Park. Within the national park itself, you're capturing elephants today.
I do not wish to ask any questions, but if time permits, can I supplement to the very, very depressing statements that you made without, if there is time, otherwise, thank you. To answer, generally speaking, you mentioned, Mr. Speaker, that about the role, very secondly, about the role of the Ministry of Environment and Forest. Incidentally, I have spent more time in that ministry than any serving officer. And therefore, it's with great pain that I have to say this. So as Prakriti, a minister 10 years ago, as a part of his achievement, said, "हमने 97% cases clear कर दिए," as if that was his chief thing. The clearances was 96. As you mentioned, the compensation of so-called compensation of the clearance of Galatia Bay and of the lowland dipterocarp forests, which are the most valuable forests in the world. Evergreen, lowland dipterocarp, Nicobar Islands, they don't survive very many elsewhere, was by planting or by creating a safari park in Haryana, close to us. Huh? Why throw dust in people's eyes? I mean, if you say we do not, then go like the Ecuador way. We don't care about. We only care for the next year's election. The rest can go to HELL. If that be the thing, but it's this kind of a facade which is even more galling. About the mention about compensatory afforestation. And I was in service at that time, the compensation for the destruction of the mixed miscellaneous forests of the Narmada Valley development, the Narmada Valley project, was by planting a weed, Prosopis juliflora, which has destroyed the most productive grassland in India of Bani. They planted Prosopis juliflora, and it's a weed, but they can count trees. You see, दो लगाया, दो काटा और 4 plant किया. Does that apply to politicians? Get rid of the old politicians and plant a few new ones. I mean, आँख में धूल झोंकना, but it's the whole thing is this, and this is something I've written in my book, and it's a paradox as far as India is concerned, that the conservation comes from the top, not from the bottom. There was a time when I was a forest secretary that there were 13 other forest officers who were as keen on forests as I was. When I was appointed forest secretary, my chief minister of Madhya Pradesh sent me a message don't take leave when you come back from United Nations, come and join quickly because there's too much pressure on the thing. I think you come and join quickly. And there were others who say, हम ये नहीं कर सकते हैं. Now you get pliant people who are thappas. They are only there to do the thing because they lose their job. And that's what matters to a bureaucrat. Postings. So this is the kind of situation now. And that is why I'll say this, that, and it's a sad commentary that we are here, that to save the forests And I'm talking about not forests. I'm talking about ecological security of this great nation, about the national natural heritage, about Aranya that has been mentioned. We have to turn to the courts. And you people are the only hope we have. The environmental lawyers, and I would like to pay a tribute to you while I am at it, that you are doing it despite the pressure. We know what we are facing. Even chaps like me and others, we are facing the thing, hum tumhara pension band kar denge, ye kar denge, wo kar denge. So, I mean, and you are doing it pro bono. God bless you. And if there is a definition, what is the definition of a patriot? A patriot is somebody who not just saves the land from being occupied by others. They are, of course, patriots, the soldiers. But what about those soldiers who try to save the motherland from destruction, desiccation, and I don't want to use a four-letter word, which starts with R, motherland. This is the irony, and this is the tragedy of the country. And as far as compensatory afforestation is concerned, the Supreme Court appointed a committee which made me a chairperson, and which we have submitted a report that all this is bogus, that this is how you should do compensatory afforestation. There are certain forests that cannot be compensated. Evergreen forests never become evergreen again. So a report was submitted almost 3 years ago. The government has not even bothered to reply to it. And to add to the conservation thing and the climate change, the FCA also says that it will not apply to areas which are politically affected, which is insurgencies, for instance, as it was in Buxar and elsewhere. But it also doesn't apply to within 100 kilometers of the border, which means the whole of the Himalayas are out. For what? Development of a few. Development. It doesn't forest conservation, so the whole act is just undermined. I won't say even thing. It's absolutely bisected and be thrown in the dustbin. I'm sorry I've taken so much of your time. Thank you.
I am advocate Nityanand Sinha. आपने जो बोला ना कि you wanted somebody to sign affidavit. If you need, you tell me, I will sign affidavits. The other point I want to make that the last resort for us is Supreme Court. And we should try and do all the efforts which can retain its sanctity. So, मैं सरप्राइज होता हूं कि कोई एमपी बोल देता है सुप्रीम कोर्ट देश को बर्बाद कर रहा है. उसके लिए 100 सीनियर एडवोकेट्स क्यों नहीं आते और एक साथ कॉन्फ्रेंस करते हैं that this is wrong, Supreme Court is not doing anything wrong, and some motor mouth is not allowed to speak like that. So that will act as a counter measure. नहीं तो कोई भी एरा गेरा खड़ा हो जाता है और बोलता है कि Supreme Court is doing this, Supreme Court is devastating the country. So that's my suggestion. We should act as a counter measure, the civil society. Thank you.
मैं यहाँ सबसे जूनियर आदमी, मैं एक रिटायर्ड फॉरेस्ट ऑफिसर जो हूँ है स्टेट फॉरेस्ट सर्विस का, सतवीर सिंह मेरा नाम है. मैं एक चीज पूछता हूँ, इफ सुप्रीम कोर्ट फेल्स एंड इफ ऑल लीगल मेजर्स फेल, तो हम क्या करें? तो मेरा ये कहना है, गो टू द पीपल, हम लोगों के पास जाएं. और उसके लिए हम कोई लिटरेचर वगैरह या कुछ ऐसा करें, तैयार करें। राजस्थान में एक केस हुआ कि वहाँ पर फॉरेस्ट एरियाज की लिस्ट बनाने का मामला चला, तो फॉरेस्ट ऑफिसर्स जो हैं वहाँ एक ट्राइबल एरिया में गए, तो उस एरिया में पहले ही कुछ लोग पहुंचे हुए थे कि तुम ये यहाँ काम मत करने दो, नहीं तो ये तुम्हारी चरागाह चली जाएगी, तुम्हारी जमीन चली जाएगी, तुम यहाँ पशु नहीं चरा सकोगे, और यहाँ वो कम्युनिटी लैंड थी, ये जो है आप कुछ नहीं कर सकेंगे। तो इस तरह से जो ये ऊपर हो रहा है, ये नीचे भी हो रहा है। हमारे यहाँ हरियाणा में ही एक हमारे अरावली फॉरेस्ट में बनने जा रही है सफारी, जंगल सफारी। तो हम कह रहे हैं कि ये नुकसानदायक है, लेकिन वो लोगों को कह रहे हैं कि 600 करोड़ का प्रोजेक्ट है, इतने लोगों को नौकरी मिलेगी और ये होगा और ये होगा। तो अपने राज्य में हरियाणा में मैंने रिटायर्ड एम्प्लॉइज को और वर्किंग एम्प्लॉइज को एक संगठन बनाया है, और हम 5-6 जिलों में जा चुके हैं और लोगों से मिलके उनको बताते हैं कि ये हो रहा है। तो मैं नहीं कहता कि भाई जरूर हम कामयाब होंगे, लेकिन मैं इतना निराश भी नहीं हूं कि हम कामयाब ना हों। तो अगर सुप्रीम कोर्ट, क्योंकि आज जो जैसा माहौल चल रहा है, सुप्रीम कोर्ट में भी इनफिल्ट्रेशन गवर्नमेंट का हो रहा है, आप मानो या ना मानो। और अगर ये चलता है और हम सुप्रीम कोर्ट में फेल होते हैं, तो मैं समझता हूँ कि आप जो इतने बड़े बड़े सिविल सर्वेंट्स हैं, हमें आप साथ लीजिए, जो आपके सबऑर्डिनेट एम्प्लॉइज हैं, और उनको तैयार कीजिए कि वो लोगों के पास जाएं, और वो हर गांव में होते हैं, हर जगह होते हैं, और लोगों को बताएं कि सरकार क्या कर रही है। हमने एक क्वेश्चन रखा कि अरावली जो है, यहीं क्यों सफारी बनाओ तुमने 600 करोड़ की सफारी बनानी है तो प्लेन ग्राउंड में बनाओ, प्लेन ग्राउंड में बनाओ, आप इसको क्यों बर्बाद कर रहे हो? यहाँ जो जानवर रह रहे हैं उनका क्या होगा, और यहाँ जो पौधे हैं उनका क्या होगा, और यहाँ जंगल है उसका क्या होगा? तो मैं ज़्यादा नहीं कहना चाहता, यही कहना चाहता हूँ कि एक आपकी तरफ से कोई एक लिटरेचर बनाया जाए। और अपने राज्य में तो मैं कॉन्फिडेंट हूँ, आई कैन रीच मैनी थाउजेंड पीपल्स। तो आप लोग भी जो है वो अपने अपने राज्य में जो हैं, मेरे ख्याल में जिन हमारे ये ऑफिसर्स हैं, इनके सबऑर्डिनेट स्टाफ होंगे और कुछ जानकारियां होंगी, तो वी शुड रीच टू देम, टॉक टू देम। और आज हम सुप्रीम कोर्ट में फेल होते हैं, तो एक दिन ऐसा आएगा जब हम कामयाब होंगे, लोग कामयाब करेंगे। धन्यवाद।
Thank you so much. I thank our members of the first session who spoke so well and gave us such a good insight on the functioning of all our boards and how environmental and forest and wildlife clearances are taking place. And I'd just like to say that we may be a small group, but we are a very passionate group. And the question answer session has also shown it to us. So thank you so much. And with this, we end the first session. Thank you.
Thank you so much. It's a really scintillating session, extremely educative. I'd like to invite the speakers for the second session to kindly take their places. This is a very intense, back-to-back kind of program. Would you, yeah, call it my name? I invite Shibani Ghosh, who is the convener of our session 2. And Shibani.
When do we wrap up this one?
But you know, I really feel if the growth was when the develop to the I इसलिए मुझे नहीं बुलाया डिस्क्वालीफाई हो जाएगा but I believe that's my wrong but votes are not for this president it's a short time why post exciting they are deciding as a last resort I thought what is it oh you said looking forward to all the shall I please start? Yeah.
Good evening, everyone. We'll begin with the second session. Can I request our speakers for today, for the second session, to please join us on stage? Dr. Ranjit Singh, Mr. Avay Shukla is here. Dr. Arvind Kumar Jha, sir. Here. Dr. Jha was, and Prakriti ma'am, who's joined us. May I, Dr. Jha is, I know he was in the audience. So we can begin with our second session. We can have everyone. So while the first session we were trying to cover various aspects of forest conservation and the role of the courts, but also the role of the regulatory agencies, the Expert Appraisal Committee, the Forest Advisory Committee, as well as the NBWL and various other regulatory agencies. The second session is, I think it has a much wider canvas in that sense, because we are hoping to cover not just wildlife conservation, looking both at the legislative aspect of how the genesis of the act, but also moving on to what I mentioned towards the end about the climate change and extreme climate events. And then, of course, a very crucial aspect of wildlife and forest conservation, which is the rights of the forest dwellers and the traditional forest communities, and then leading on to almost naturally to what often is the human-wildlife conflict and what the kind of wildlife crimes and the kind of disputes that we are seeing in the wildlife conservation landscape. So it's quite a variety of issues we have, but we have for this, I mean, a stellar star cast speaking to us today. We have Ranjit Singh sir, Dr. M.K. Ranjit Singh. I don't think he really requires much of an introduction. given his background, of course, a former Indian Administrative Service officer, and he joined the service in 1961. We know he's the author of the Wildlife Protection Act, 1972, which he drafted, was a key player in drafting that when he was part of the government of India. He also served as the chairman of the Wildlife Trust of India. He was the Director General of CAPART, and of course has held many other roles. He has published extensively. Some of his publications include, more recently, Life with Wildlife from Princely India to the present. He has, of course, played many roles, and I don't want to go in detail, but I think Sir's commitment to someone so new to this area, I think, is so inspiring. I mean, I receive emails from him at 2 a.m. and 3 a.m. Just, these really incisive and detailed comments, which really just show what an eye for detail, but also just Sir's deep commitment to the cause. Thank you, Sir, for joining the panel. Our second speaker today is Mr. Avay Shukla, who's going to speak to us about the extreme climate events in Himachal and Uttarakhand. Sir here joined the Indian Administrative Service in 1975, and he served in Delhi as well as in Himachal Pradesh in various capacities. And he retired in 2010 as the Additional Chief Secretary of Himachal Pradesh. He writes extensively. I'm a big fan of his blog, as many of us probably are. And he writes on current affairs, the environment and conservation. He's written several books, including The Trails Less Traveled, The Spectre of Chudhar, and India, The Wasted Years, and there are many other publications. Looking forward to hearing you, sir. Our third speaker today, an expert, of course, in Forest Rights Act, Dr. Arvind Kumar Jha. He's a former Principal Chief Conservator of Forests and Director General, Social Forestry of Maharashtra. He's currently on the advisory board of the Sacred Groves, a community interest company of the UK. He's an expert member of the Committee on FRA Implementation, Forest Survey of India. He's a founder trustee of Global Enviro-Legal Services Foundation, apart from, of course, being member of various committees, and a member of Bar Council of Maharashtra and Goa. Sir also has written extensively on these issues, including books and articles. Moving on, our final speaker of the day, Prakriti Srivastava ma'am. She was the Indian Forest Service Officer, 1990 batch of Kerala cadre, and retired as a PCCF in Kerala. She has over 3 decades of expertise in forest management, forest policy and law, wildlife and biodiversity conservation, protected area management, and international wildlife conventions like the CITES. She was appointed as a country director of Wildlife Conservation Society, the India program. She and her team had earned a reputation of effectively working against illegal encroachers, wildlife traffickers, timber smugglers, and illicit timber factories in some of Kerala's most important landscapes for wildlife. She's working with key government colleagues. She created 4 new national parks and to improve the protection status of many other forests, and initiated in collaboration with local communities a highly successful olive ridley turtle conservation program. And ma'am today will be speaking to us about human-wildlife conflict and wildlife crime. Without further ado, may I request Dr. Ranjit Singh. Sir, would you like to speak from there? Would you like to come to? Please.
Friends and colleagues, I would first like to thank the organizers of this conclave to have invited me, and I'll try to give it a slightly different angle than purely legal one. But the subject area on which I have to speak on is about the creation of the Wildlife Protection Act. I wouldn't like to go so much into the and the genesis of it and the history of it. But there are a few clarifications, as you may wish to know, which refer to the legality of it. I'll try to keep it in time. or will you please let me know? Firstly, what is wildlife? And I have incidentally, and this is not not boasting, the act was drafted by only two people, Mr. Basham and myself. He was the Deputy Secretary, my colleague in the Legal Affairs, and myself, and there was only one person to help me, Mr. Ed Kohli. The others are both gone. I'm still surviving. So if there are any faults, it's my fault, actually. And the government allowed me to even amend the act right up to about 2004. And therefore, if there are any lacuna, I take the blame. After that, Bhagwan Malik hai. So anyway, the idea of wildlife, and this is particularly in reference to the animals. It was, incidentally, I wanted to frame it the Wildlife Conservation Act. But the Constitution of India says wildlife preservation. And therefore, Bhashyam insisted that it should be. So even the word wildlife are two separate words. For convenience and for parlance, we but the Constitution says wildlife separately, and it says preservation, not conservation. And therefore, Bhashyam said, तुम जाओ और Constitution change करके आओ, फिर जो लिखना हो तो लिखो. हमने कहा that's too much of a thing. So, but he said, तुमको जो डालना वो डालो. So conservation is a much wider, because it means management. Preservation is just pure preservation. I wanted conservation, but I had to settle for Wildlife Preservation Act. But he allowed me to put in everything I wanted. So it is a lot about management. The ethos was totally different. The ethos was such that when the act, when I suggested to Mrs. Gandhi in a wildlife board meeting, not a wildlife board meeting, what am I saying? In a private meeting she had of wildlife people, which I was the youngest chap, and I went there because my colleague happened to be my batchmate, happened to be her deputy secretary, and I'd shown her my wildlife films. And I suggested we should have a wildlife act, and we should have a conservation assistance scheme to parks and sanctuaries. And she agreed with both. I was in the Ministry of Environment. Sorry, there was no Ministry of Environment. I was in the Ministry of Agriculture and Food, handling machinery, if you please, because we are supposed to be Chitla service, the IAS. So I was handling that and hoping to do something with forest and wildlife. But I went back to machinery and RSO 9 tractors. And 3 days later, a message came to Fakhruddin Ali Ahmed Saab, my minister, that Ranjit Singh should be put in charge of wildlife. And that's how it started. And I went to the Ministry for Law, and I was very well received. And I was given this man as a nodal officer to coordinate and to draft the act and pass him. And he said, sorry, I have no time. We can only, this is May, we can only start in September onwards after the monsoon session. So I put back a note, say that the I went there and I was very well received. But they cannot start. We cannot start drafting because I was told that the person concerned, without taking name, won't be free to do it till September. As the PM was very keen that we should do this work quickly, the PM may wish to see. That was good enough. That was a magic word. The PM may wish to see. After that, everybody put a Dhobi mark. My IG Forest, Mr. T.P. Singh, ICS, Fakhruddin Saab. On the third day, I get a phone call from that same Mr. Bhashyam, Parson kal aa sakte ho? We'll start. That was the interest. That was conservation from the top. Somebody in the top was interested, and therefore it could happen. I'm not going to do the semantics of it, but coming to this is how, and the draft and the act was drafted in 4.5 months, of which a month took. I was delayed because once it was circulated, the draft, to the Ministry of Tribal Welfare Department says this affects the traditional rights of the tribals of hunting. So I said, you had all kinds of tribal rights, including Akhand Shikar, including Bharat in Bastar, where they set fire to everything and kill everything. So what do you allow? So I, being a bureaucrat, I said, I sent a circular around. I said, is there any traditional hunting right of any local community tribal which is recognized on any piece of paper? And only Nicobar came, Andaman and Nicobar came out, that in Car Nicobar, thanks to a very progressive bishop who had converted Car Nicobar into Christians, there was this right that they have the right to hunt, and nothing is, they don't require things. Just like Coorg was the only area in the whole of India who had an exemption from the forest, from the Arms Act. The Coorgis did not have to have an arms license. This was the only exception there. So I put it up there. And that is still there in Section 64. That act, that exemption for the thing, that this act will not apply to this. The tribal rights of hunting still exists. Thank God there is nothing left on Car Nicobar. So they've already finished it. And therefore, when the matter came up before Parliament, I was sent for by Mrs. Gandhi, and I just walked across from Shastri Bhavan to Parliament, and she was there, and I asked her secretary about why I was sent for, and he said the tribal members of Parliament wanted to insist that they should have the rights to carry weapons inside sanctuary or park, or tribal rights of hunting should be recognized. So I went to see her, and she looked up and said, the tribal members of Parliament are very angry with my act. So I said, what about Rose? So I was ready, and I said this. I said, Madam, if you allow that, then you may not have the act. And I said, Madam, then any other community will say they have traditional rights of hunting. And then I threw a googly, because she had just passed the constitutional amendment which finished with the privileges and the privy purses of the princes, and I come from that background. And the princes had the right to hunt in their own area under the constitution around everything. They were exempted as a part of the merger agreement. So I said, Madam, if you allow that, nothing will remain, and then other communities. So he says, you talk to them and get it over. So I said, Madam, the act is coming up for this evening. Will it be passed? She said, of course it will be passed. That was it. Then I could talk to doomsday. This was what I'm trying to say is that when you have this kind of support, it happened because that was where it mattered. And now, when the focus is somewhere else, we have seen what is happening. Now, as far as wildlife is concerned, and I made it a point, it is not just animals, but the habitat. And the habitat is far more important than the animals itself. Because you can have the habitat without the animal. You cannot have wild animals without the habitat. You can have them in safari parks and Vantara. So, which are caged animals. And there's a very big difference. But the whole idea was to use animal to save something far more important than the animal itself, the habitat, the ecosystems. The propensity of the ecological services that can be rendered, and that is what is being affected. I'm digressing, but during my second tenure as Director of Wildlife, I took an account, and 486, I think, perennial streams came out from our national parks and sanctuaries then. When the Palamau National Park was created, they were, and it's a rain shadow area in Bihar in those days, Jharkhand now. The DFO, I wish I had done that elsewhere too, took account about what were the streams. And he divided the streams into 4 categories. Those that stopped flowing at the end of September, those that flowed up to December end, and those that flowed up to March end, and perennial. And 3 years of stoppage of illicit cutting, grazing, fire, and human demographic impact, the streams came, which ended in September, monsoonal, became operative till the end of December. December ones went on till March, and March ones became perennial. If that was what the Palamau Tiger Reserve was giving to the people of India, it was more important than 6 tigers that lived there at that time. That was the government of Gujarat. The Agriculture University of Gujarat, which is based in carried out the ecological services of the Gir National Park. The Gir National Park, those which are within 15 radius of 15 kilometers from the borders of the Gir, were getting roughly 35,000 rupees per acre profit. Those that were beyond that 15 kilometers, the revenue dropped almost half. And this is despite the fact that the damage done to those areas close to the park, it was far more, both by the lions, leopards, as well as by the wild animals, nilgai, cheetal, and this was the benefit. And the kesar keri, which we all know, grows only in the area close to the park, not elsewhere. The real ones, the best ones. Okay, sure. Now, so this is the important. Now, the area of the national parks and their sanctuaries, which should be sacrosanct, are now being reduced, not added, for frivolous reasons or in the name of development. Be as it may, the fight has to go on. I will not go into the details of the act. I've already run out of time. But I will say that this is, and so does the other act. If the Wildlife Protection Act of 1972 is, and if pressure is brought on, I'm sure the government will go ahead and amend the act to make it pliable, easy to. We have already seen how it's been misused or manipulated. Then I would expect that the only recourse is to go to court. And I would then request and hope that we'll have the support of as many as possible. And we have to therefore go to the common man to say that this is not just saving of tigers and lions and leopards, but of ecological security of the country. That these are the last havens of hope for the survival of Mother Nature and of the national and natural heritage. Thank you very much.
Good evening, everyone. Just as an aside to begin with, in her initial introduction, Aditi, when she was talking about the Constitutional Conduct Group, said that it doesn't have an address. But that made me feel like a voter in Haryana, you know, just as an aside. Now, I'll basically be talking to you about natural disasters in the Himalayan states, with special reference to Himachal and Uttarakhand, not the other six, because that would take up too much time, in giving statistics and figures about the other states. But believe me, what is happening in Himachal and Uttarakhand is precisely what is happening in those other states, whether it is Sikkim, whether it is North Bengal, whether it is Kashmir or the other northeastern states. And to understand it, the natural disasters in the Himalayas, there's nothing new about it. It's been happening for a long time. That's primarily because the mountains are young. Unlike the mountains in Europe, the Alps and the Pyrenees, the Himalayas are still being pushed up by a few millimeters every year by the Asian plate. So they're growing, they are friable, they are fragile, the geology is very unstable, they're prone to landslides and avalanches. It also, unfortunately, the entire belt, the Hindu Kush belt, lies in the highest seismic zones, 4 and 5, which just adds to the fact that natural disasters occur here with much more intensity and in frequency than in the rest of the country. Unfortunately, that is not something which the governments have factored in their planning and development processes. So there are basically, now this year it's still fresh in our minds, the kind of disasters that took place in, what was the name of that place? Dharali. The flash flood in Dharali in Uttarakhand, the disasters that have been taking place for the last 3 to 4 years in Himachal, the Manali area, the Mandi belt, the Chamba region. I'll just give you some figures. In just the last 3 years, Himachal has lost more than 1,200 lives. It has suffered a financial loss of more than 18,000 crores, not counting the loss of economic activity. So this really makes one question, and it is spending far more than this in providing relief and damage compensation. So one would think that the government would realize that the cost-benefit ratio of the kind of development which is being done there is not positive. They are spending more than they are earning. And Uttarakhand is even worse. In the last 5 years, the same period I gave the figures for Himachal, the loss of lives in Uttarakhand, including the Kedarnath disaster, has been more than 15,000. And these are the government reported figures. I am sure the actual figures would be much higher. And the financial loss has been more than 50,000 crores. Uttarakhand. There are three reasons for this. One, of course, is, like I said, the nature and geology of the Himalayas lend themselves to disaster, something the government should factor in. The second reason is unsustainable development activities, anthropogenic activities, regardless of the delicate balance which has to be maintained in the mountains. And the third is climate change, which is beginning to manifest itself in the last 3-4 years, particularly, and which is no longer, I don't think you can call them erratic weather events or extreme weather events anymore like we used to. This has become the normal pattern now. The weather has changed, climate has changed. In this year, in Himachal, I managed to get these figures. During the monsoons, we had heavy to very heavy rainfalls, what government parlance calls cloudbursts. You know, it's a very convenient term. For 90% of the monsoon months, that is July, August, September, on 90% of these 90 days, the precipitation was between 105 millimeters to 205 millimeters per day, which the meteorologists classify as intense rain, or the government says is a cloudburst. We had 27 cloudbursts. Cloudbursts have been occurring in the mountains for ages. There's nothing new about them. What is new about it and what makes it so dangerous, as we found in Dharali or the Rishi Ganga tragedy, where the entire dam was wiped out, it's basically excessive rain and glacial melt and glacial lake outburst flow, which is causing these massive disasters along the rivers in these mountain states. So these are the three main reasons. The effect of climate change is something which the governments are not studying, not seriously at least. For example, one major factor we need to watch out for is what is happening to the glacial lakes in the Himalayas. They are expanding in number. Remember, there are 7,500 glacial lakes in the Himalayas, these 7 states we are talking about, and these are the official figures of the department, the Environment Department. The glaciers are retreating at a massive rate because of global warming. The Gangotri is retreating at 12 meters per annum. Per annum. Its tributaries are retreating at between 25 to 30 meters per annum. Now, this is happening across the board, resulting in a creation of more glacial lakes. The number of glacial lakes has multiplied exponentially. And the expansion of glacial lakes, which is where the real danger and the threat lies. Because the glacial lakes, when they expand beyond their capacity, the waters are held up only by the moraine at the foot of the lake. And when the pressure intensifies, when the lakes expand, someday the moraine gives way, and we have the kind of tragedies I have just mentioned. We are not prepared for that. We are not planning for that. And we are not taking the steps, preventive steps, in our so-called development processes, which should be taken to ensure that at least around these areas, we try and reduce the warming. The Himalayas are warming at twice the global average. Global average has already hit or is crossed 1.5. The Himalayas are warming at twice that rate. So you can imagine the impact it's going to have on the glaciers. There are a number of reasons for this. I will not go into the other reasons. I'll just highlight three main areas where the government needs to reconsider its development processes. These are the areas where, these are the reasons where the maximum environmental impacts are being caused. The first is hydel projects. The second is tourism. And the third is road construction. To give you an idea of the hydel scenario, I'll just share with you the Himachal hydel scenario. Himachal is one of the leading states in the production of hydel power in the state. We have a capacity of 27,000 megawatts. Explored capacity of 27,000 megawatts. And the government is hell-bent on extracting each megawatt from our rivers. In the process, causing most of the damage to the environment which is taking place currently. And Uttarakhand and North Bengal and Sikkim are precisely the same. The Tista tragedy took place, I think, a couple of years ago in Sikkim, when the entire Tista 2 or Tista 3 was washed out. Our identified potential is 27,000 megawatts. So far, we have commissioned 13,000 megawatts already in Himachal. 5,000 megawatts are in the pipeline. The remaining 8 or 9,000 megawatts is what the government is after now. And alarmingly, the low-hanging fruits have already been taken. The hydel projects possible in the Satluj, the Beas and the Ravi have already been fully exploited. Now the potential lies in the tribal districts of Himachal, Lahaul Spiti, the upper areas of Kinnaur and Pangi of Chamba district. Now these are the most ecologically fragile areas in the entire fragile Himalayas, and building huge projects there, constructing roads to take up heavy machinery, blasting and tunneling in those areas. I cannot even imagine the impact that this will have on the environment over there and on the glaciers and the snowfields. Forget about the wildlife. But the government is hell-bent on doing it. They have already floated tenders for 4,000 crore projects to 4,000 megawatts worth of hydel projects in these three districts which I have named. They are doing the same thing in Ladakh. They are doing a massive solar project for which a high-power transmission line is being built from Ladakh to Haryana through the heart of the Himalayas. And it has already been cleared, and we all know who is likely to bag that particular project. Now, the impact of hydel projects is exponential insofar as our rivers are concerned. Apart from killing the rivers, which is a separate aspect altogether, the road construction, the dumping of muck, all of it finds its way back into the rivers. It is silting up the dams which have already been built. 40% of Bhakra Dam has already been silted over. It has lost its capacity. The dams were touted as a flood control measure. Instead, what they are actually doing is enhancing the threat of floods in these rivers, because when you have a dozen dams, let us say on the Beas, and all of them are brim full during the monsoon, no water is released by the dam authorities, because for them water is inventory. They don't want to release the water unless it becomes absolutely unavoidable. So all the dams are brim full of water up to their high flood level, and then suddenly the Met Department forecasts, or it starts raining for the next 1 week non-stop, which is the extreme weather events which have now become common. And all 7 dams will release their water simultaneously. You can imagine the impact downstream. Punjab, what happened to Punjab this year, I mean, the major part of it is contributed by the dams of Himachal Pradesh. They are killing the aquatic life of the river. The river is an ecosystem. It's not just a conduit for water, but the rivers are being killed. As Forest Secretary, I got 2 rivers mapped, the Ravi in Chamba, and I'm talking of 2010, 2009-10. It must be much worse now. I got the Ravi and the Satluj mapped. Now the Ravi is, the length of the Ravi in Chamba is 70 kilometers, out of which 67 kilometers has gone underground. There is only 3 kilometers of the original river left in Chamba district. All the rest have gone into headway struggles to power the various hydel projects. The length of the Satluj in Himachal is 239 kilometers. Only 19 kilometers is left of the river. The rest has all gone underground. So, these may not be visible, but these are the ecological impacts. A river recharges aquifers. It promotes greenery along its course. It has aquatic life. None of this matters to the government in its pursuit of. In 2010, the Himachal High Court had set up a committee to examine the impact of hydel projects on the environment. The committee supported this report in 2010 itself, and it had made some very important recommendations, which the High Court accepted. For example, it said there should be no-go areas where no project should be sanctioned. Obviously, catchment areas of rivers, dense forests, wildlife habitats, snow fields, and glaciated areas. There should be cumulative environmental impact assessment for an entire basin, not for a single project. Because every project does not have simply an incremental environmental impact. It has an exponential environmental impact. And, it's where the sum of the part is more than double. The committee recommended that there should be a minimum discharge maintained in the rivers throughout the year. Right now, what happens is during the lean season, there is zero discharge, completely killing all aquatic life. Committee recommended 25% of peak flow should be maintained. And that there should be a minimum distance of 5 kilometers between 2 hydel projects. Right now, you have hydel projects every 500 meters. यहाँ का outflow आया पहले वाले project का 500 meters below that you have the intake for the next project. Then you have another outflow for the second project. After 100 meters you have a... So that's why the rivers are disappearing. Okay, the second problem is road construction. 4-lane highways is the new mantra for Mr. Gadkari, and our chief ministers are absolutely hypnotized by the prospect of 4-lane highways in their states. Himachal at the moment has 7 4-lane highways being built there. Somebody spoke earlier of Char Dham and the damage the Char Dham highway is causing. Same thing is happening in Himachal and in Uttarakhand also. The Kedarnath tragedy is not even 10 years old, and now apparently there a highway has been sanctioned to Kedarnath, from where, Joshimath or wherever, all the way up. We've seen what's been happening to the Dehradun highway and how it is being built within the river, not even next to the river, along the course of the river. Elevated highway is being built between Dehradun and Mussoorie, so that tourists can reach Mussoorie in 26 minutes. The number of cars going to Mussoorie will go up by 10 times. Mussoorie has parking for only 4,000 cars. Where will you park them? The same thing we are already experiencing in Shimla, because our Kalka-Shimla 4-laning, which is a disaster, it's been going on for the last 12 years, has already created this problem. Shimla has parking for 6,000. We get 20,000 cars per day. This all adds to the environmental impacts, the over-tourism, And tourism is the other big, what shall I say, danger to the Himalayan states. Himachal at the moment gets 2 crore tourists every year. The Himachal Chief Minister has set a target of 5 crore tourists by 2030. आप इनका इंफ्रास्ट्रक्चर कहाँ से बनाएंगे? सड़कें आपको बनाना पड़ेगा, नए शहर बनाने पड़ेंगे, वाटर सप्लाई कहाँ से आएगा, पार्किंग where will you provide the parking? How do you take care of this over tourism? I could have spoken more about this, but I won't. I'll just end on this final thing that perhaps one solution, because basically at the end of the day, Himalayan states are deficit states. They are financially non-viable. They were created for considerations other than economic. They are not viable. And in order to generate their revenues for development, which has to be done by any government, in order to generate those revenues, they are desperate to ruthlessly exploit the only natural assets they have, which is water and forests. And both are disappearing. Himachal has diverted 11,000 hectares for non-forest activity, dense forests for non-forest activities in the last 15 years. Uttarakhand has probably done even more than that. So one solution is for the Finance Commission to evolve a mechanism, what is now being called a green bonus or a green incentive, after calculating the ecological services which the mountain states provide to the rest of India. For Himachal, the Bhopal Forest Management Institute carried out a survey last year. They have quantified the wealth of Himachal's forests at 9.5 lakh crores. And the annual economic environmental benefits which these forests provide to northern India at 3.5 lakh crores per annum. This is in terms of carbon sequestration, ecosystem services, water, timber, etc., etc. And I'm very glad that the Constitutional Conduct Group has taken note of this matter, and we have just recently written a letter to the chairman of the 16th Finance Commission requesting him to address this particular thing. Especially, even the Supreme Court has taken notice of it. In a recent judgment, the Supreme Court ordered that if Himachal does not stop this kind of non-sustainable development, it will vanish from the map of India. So we are hoping that perhaps the CCG's letter to the Finance Commission may make an impact. It has been suggested that a separate fund of 50,000 crores should be set aside by the Finance Commission for compensating the Himalayan states for the ecological services which they provide for the rest of India. Thank you. Thank you very much.
Thank you, sir. May I now invite Dr. Jha, sir, to speak on implementation of Forest Rights Act? Sir, ka presentation.
Yeah, namaskar, everybody. I'm so happy to have been invited here to share my experiences about the Forest Rights Act's implementation. I was Commissioner Tribals when I was given this responsibility of implementing this act in Maharashtra. They thought that this fellow is a forester, and so he may be he will start doing Nakhara, and all the foresters, they thought that I'll do everything in favor of the tribals. So that was the kind of situation in which I started. But let me tell you, right from the beginning, it has lot many issues and concerns, of course, depends who is looking at it as an issue. Next, please. I'll just start with a bit of data. Please don't, I also don't remember it. But the fact is that we already have claims to the extent of 50 lakhs, more than 50 lakhs, out of which about 50% have been cleared by the respective district level committees all over India. And this is about the individual forest rights, and there are community forest rights also, which are to the tune of around 2.1 lakhs, and about 1.8 crore acres have been dedicated to that. Let me put thing in proper perspective, in the sense that this act is not meant for every tribal, and it's not meant for every forest dweller. It is very specific act. It has a beneficiary set of only the forest dwelling scheduled tribes and other traditional forest dwellers, which are properly defined in this act. That is one thing that this act has done, which we can call proper. Next, please. I'll start with individual forest rights. That is the right to habitation and self-cultivation. Self-cultivation. Not that you stay in Delhi and have a plot somewhere in a tribal area and you claim. Now, after this act was promulgated, in 2012, its rules were amended. The amended rules were such that it reversed the transparency of the examination of the evidences. That means the satellite images that were being used earlier, it was declared to be only as a supplemental kind of a proof and not as a primary proof. So it could supplement some other evidences. The first thing that the government did through the amendment of the rule was to reverse the transparency. Second thing was that we tried to say that this is one of the most powerful things in favor of the most genuine claimants who had no other documents to prove that they were on a particular date, which is fixed on the fixed by the Act, that is 13th of December 2005. They were on that land, but they could get a benefit of satellite images and have those rights. So it went against them fundamentally, those who had no other evidences. But then it went in favor of all the fraudulent cases where they were all encroached after 2005, that is 13/12/2005. So this kind of a work that was done was basically against the most genuine people and in favor of the fraudulent ones. And the kind of administrative nightmare that we are facing today in the society as well as in the administration, I'll show you through some of the slides. This is Maharashtra case. We had in Maharashtra 13-digit code attached to every claimant, which gave his district, taluka, village, and its name also. And that was attached to the polygon, that is the GPS polygon. And that was overlaid on the satellite image. So this was one of the best ways to find out whether, as on 13/12/2005, he was cultivating or not, or he was residing there as a matter of fact or not. There were cases where much more than cultivation area was claimed. This is a case of Thane district, where you get land, you can buy land at the rate of a square feet, certain 1,000 rupees a square feet, and this is the kind of demand that he had made on the committee. This kind of a change in the land use, earlier it was forest land with, you can see the contour trenches that is normally done by the forest department, and that was all damaged by 2012. This is a Yaval sanctuary in Maharashtra. All the guys from Madhya Pradesh, they came and settled there, and all these red dots you can find, they are all illegal claims, illegal habitations that started after 2005. This was a plotting exercise being done everywhere. That was a situation in many of the places in Maharashtra. because we had very nice, smart gentlemen operating just like builders, you know. We, as a very conscious department, the forest department, not the tribal, the forest department studied this area, this case. Totally, we got 43,000 cases studied. Oh, I was the culprit. Oh, sorry. Obviously, it was offering a lot of loan to me. That happens, sorry. So we took 43,000 polygons, overlaid them on the satellite images of 2005, 6, 7, 8, and 11, 12, and found that there were so many irregularities that were happening on the ground. This was around 12, 13, and the total study output showed that about 14% of the area that was being given was illegal. This would not have been found out unless we would have had used a satellite image system, that is geoinformatics. But despite this, the tribal department chose to remove that satellite image as a primary evidence. Maharashtra was not unique. Madhya Pradesh, you can see on the in the area on the left side, you can see how the area was totally decimated and brought under cultivation. Podu Pattaj from Telangana. Now the CEC has taken cognizance of that recently. That's something good. This is Sendwa, Madhya Pradesh, sir. आपका पुराना कैडर बर्बाद करके रख दिया हम लोगों ने. So this is the kind of area that was demanded and allowed. Okay. Let me go on a fly. So this is Dhar division, sir. You can see the kind of, oh, sorry, next, sir. Next, please. Next. You are going next. Yeah, this is Sendwa. Next. You can see this is the kind of areas that have been claimed and allowed by the district level committees. And all of these are not under agriculture. Most of them are under natural vegetation. This is Dhar district, sir. Khargaon. You can see how beautifully they have all made the plots. This is also from Khargaon. And there are n number of, almost every district I have the plotted details. It has been sent to the government. Nothing happens. And on the top of it, the Ministry of Tribal Affairs have been issuing letters, guidelines. You can see all these guidelines. They only say, please reopen the cases, please reassess, please relook at the cases which have been rejected. Not any of the cases which have been wrongly allowed. So that is the kind of stance the tribal department has been taking. Now I come to the Supreme Court. When I was coming here, my wife said that please criticize everyone, don't criticize the Supreme Court. So I'll not criticize. So no, she's dependent on my pension. Yeah. So there was a case right in the 2008. It came for hearing on February 13, 2019, when the Supreme Court said that all those who are encroachers, they should be pushed out, thrown out. Within a week, no, not 12 days, or 15 days, within a fortnight, the Ministry of Tribal Affairs approached the Supreme Court, got a stay on this. And the logic was, we have not followed the proper procedure, and therefore it will be an injustice to the tribals. Supreme Court did not say anything about the people who had not followed the procedure, but yes, they have stayed it. Now, this is the situation when you have committed so much of wrong, and then you are trying to retrieve the situation. Even the Supreme Court And after that, it has not come for hearing. Only 4 months time was given for all the to all the states to file affidavits detailing what procedure was being adopted there. This was about the individual forest right cases, that is the cultivations, and most of the cultivations which are on the slopy areas which have been allowed, they obviously are the centers of future disasters. Let us be very clear about it. Let me go to another section. Only 3 sections I'll talk to you about. One I've already talked. Second is 3.1c, that is about minor forest produce. This is a trade of tendu patta, basically, bidi patta. And here also, the Ministry of Tribal Affairs didn't do much of a mistake, but the states did. The states have misread the provision. The provision says that the forest right will be given to the forest dwelling scheduled tribe and other traditional forest dwellers and their communities only to the extent that was being traditionally collected by them for their bona fide use. This is the exact terminology used in the Act. What we have done is, we have handed over the entire commercial minor forest produce output and trade to the Gram Sabha, irrespective of the fact that Gram Sabha may not be qualifying as a committee per se. They need not be all dependent on the forest or forest land, or they may not be forest dwelling scheduled tribes, all of them, or the other traditional forest dwellers. So this is a situation in which the whole area, the whole trade has gone from a government controlled trade, for which we are criticized that you are trying to have your hegemony on. But the fact is that it always had stopped the private players, and that was the intention behind nationalizing these producers. And the funniest thing is that the claims that have been submitted to the district level committees had the quantum mentioned in that. You have to mention nature as well as extent of all the rights. Then only you can talk of sustainability. The extent was mentioned as whatever is available, whatever is used, grazing for all cattle that exist, etc., etc. That kind of a quantum was mentioned, and the DLCs, district level committees, they have sanctioned this kind of a forest right. Imagine what is happening on the ground. Tomorrow, suppose they take out everything, and next year they can go to the court and say that this is my constitutional right. To this extent, please give it to me. So this is how the states have really misread and done a lot of problem. Now the spin-offs are very interesting. Madhya Pradesh again. Madhya Pradesh and Chhattisgarh, they have a beautiful federation system. It's based on cooperative mechanism, doing very well. Now suddenly there, the governor, he takes a meeting only last month, and he says that 3 minutes, okay, I'll try and finish it, ma'am. So he says that we should have a company for minor forest produce handling now. Now that is the kind of spin-off. Maharashtra, what is happening is new intermediaries have come. The contractors, some of the NGOs have become contractors now, and they are selling in league with the earlier business people who are in the tendu patta trade. There is no audit going on. And interestingly, the empowerment, which is the basic idea behind the Forest Right Act, empowerment of the FDST and OTFDs, that is thrown to winds. Nothing is happening on that ground. Third, and the most interesting part, is the community forest resource rights. A new thing, that is, you are handing over the management of the forest to the communities. Now, this act says that this management can be given only on community forest resource. Community forest resource, which is again defined under the act as customary common forest land. Are we on the same page? Because of you only, I think we are losing time. No, anyway. So, customary common forest land is some land which is totally under the control of the communities, not otherwise. Whereas what is happening in the whole country today is that they are giving this right on the forest department's land, day in and day out. So there is a clash happening between the forest department and the communities. Tribal department is in favor of the communities. And the fact remains that all these rights that have been given, they are all illegal. So to the extent of 1.8 crore acres of forest land of India, they are under illegal grant of community forest resource rights. The processing has been terrible. It's a Mendaleka case, which is a very famous case in this country. Thrice the same right was given with slight modifications. They overfelled, they clear-felled the bamboo areas. Fires have been rampant in those areas. And this is the situation of handing over a certain area without assessing that they were having an experience in managing those forests, which is a requirement under this act. So the third part also, and this is interesting, Bangladeshi refugees have been given all kinds of rights under this act. They are all FDSTs and OTFDs. Inside wildlife areas, sanctuaries, forest rights have been recognized of management and management to the villagers. So just imagine what will happen to the management of those areas, and all that is illegal. So there is a burden of error that we have to now have on our shoulders, because political actors have used and are now using it as vote bank. Revisiting of the rules for correction, satellite imageries, resurrection, all that is extremely difficult. And if it is done, it is going to create a lot of legal, political, and social hurdles. Perhaps that's one of the reasons why even all the authorities in this country, they don't want to touch this act or these beneficiaries at all. So major challenges that remain now, last slide, is what will happen to the future of landscape approach that is required, because we want watersheds, we want eco-services. The extent of forest right not specified, so what will happen to the sustainability? There is a lot of PESA, Biodiversity Act, Joint Forest Management, and all those areas, they are crisscrossing each other in terms of their control systems. And the biggest thing is how to change the perspective of the Ministry of Tribal Affairs and ask them to become inclusive in their approach, because they are now legislating on forest matters. They are super forest department now. So MOEF ko sir abhi uske upar ek aur ministry aa gayi hai, and that is Ministry of Tribal Affairs. They are managing all this and making people understand that charity beyond law is cruelty to others. You must follow law, act, but charity beyond law is going to be cruelty to all others who are other stakeholders. So with that, I finish it. Thank you so much. And any questions, of course.
Thank you, sir. Can I now request Prakriti Srivastav, ma'am? She's going to speak to us about human-wildlife conflict and wildlife crime.
Thank you. So I'll start with saying that we won't have a society if we destroy the environment. This was said by Margaret Mead, who was a cultural anthropologist who spoke a lot about the impact of people on the environment and how they interacted with it. So in this background, I would like to speak about human-wildlife conflict and its implications. So what is the issue? Just by listening to the terminology human-wildlife conflict, it implies that there are two groups, that is humans and the wildlife, and they are at a clash course of fighting with each other, and where there has to be a supremacy which has to be established. And from a human-centric point of view, it is always the wildlife which is a nuisance, it is a pest, and it has to be overpowered so that human beings can survive. So that is the way we look at, next. So that is the way we look at how this issue of conflict exists. But how do we state it scientifically? If we look at it scientifically, and the IUCN Species Survival Commission has defined it as struggle that emerge when the presence or behavior of wildlife poses an actual or perceived direct and recurring threat to human interests or needs, leading to disagreements between groups of people and negative impact on people and or wildlife. So therefore, if you look at it from the scientific perspective, don't go so fast, please, on that slide itself. I'll tell you when to change it. So basically, if we look at it from the scientific perspective, it is not that there are two groups and who are clashing and who are wanting to find a supremacy, especially not the wildlife, because wildlife has got no intentions and it has no mens rea. So therefore, it is basically the fact that there are spaces that are going to get shared, which leads to how do we exactly find a solution to this problem. And more than that, it is groups of people actually who are having different ways of addressing this problem, and that is quite contentious very often. So what is it that actually is this human-wildlife conflict? We can understand that with the growth of population, human population, with the growth of our infrastructure, agriculture, as well as climate change, etc., that spaces of human beings as well as wildlife are getting more close. And as human populations grow, then the wildlife spaces are getting squeezed. And that leads to the wildlife also coming out into the spaces of human beings. And that causes this sort of a negative interaction, which we call as human-wildlife conflict. So we can also understand that in the 18th to the 20th century, that was the time after the Industrial Revolution, when human beings started the expansion of agriculture, where interactions of this sort increased. As agriculture developed, we found that the landscape changed, the natural ecosystem changed, and it was more of an agricultural base that happened. Commercial crops started taking place, cash crops were there, and this ecosystems which were having many types of species were now being replaced by monocultures. So this ended up disrupting the spaces of the wildlife and their ecosystems and the requirement of what they would traditionally use as food. And then it resulted in them coming and the herbivores depreding the agricultural crops, and the carnivores actually attacking the livestock. So basically, this is what happened in the name of human-wildlife conflict. Also, we found that as townships and cities grew, this further aggravated the problem for the requirement of housing, for the requirement of roads, etc. This actually ended up aggravating the problem. So, in response to trying to find a solution to this, that human beings try to find ways to ameliorate it. And most of these type of amelioration plans were something that were very damaging to the wildlife. They tried to contain them. They tried to build, enclosures. They tried to build barriers. And as you can see, this is a barrier which was built in Nagarhole using rail tracks. And you can see that the elephant, which when trying to cross over, got crushed when it was crossing over. Next, please. So the same way that you see that the infrastructure that was created, that the babies are finding it difficult to cross that the middle barrier, and this is what is causing so much of conflict and problems also. And most of these measures don't work actually, because you see again that agriculture is there, which is having palatable crop right next to the forests, and therefore the elephants come out attracted by these palatable crops, and then that results in the loss of or attacks on agriculture as well as people working in the fields. So also we should recognize that what is it exactly that wildlife requires? It requires habitat. It also requires good habitats, not just having monocultures. And there are many species which are migratory. For example, tigers, elephants, they move from place to place, and therefore they require that connectivity to move from one forest to another. So as to be, and that is inherent in them, that is genetic in them to move. And what is happening is that when we are breaking their barriers or their connectivity, naturally that results in a lot of negative interactions between humans and in people. So let us look at what exactly is going on at the larger level. We find that our forests are being diverted in a huge way for developmental works. By the ministry's own admission to the Lok Sabha in a question, it said that from 2014 to 2024, as much as 1.73 lakh hectares of forest land had been diverted for infrastructure, and the main purposes for which it was diverted were hydropower projects and mining. They were the main diversion projects for which it was diverted. As far as the National Board of Wildlife is concerned, as we previously mentioned, that from 2014 till date, it was found that 97% of the proposals placed before it have been passed. And so much so that in just 1 year, that is 2020, 1,792.51 hectares were diverted for all these type of infrastructure projects. These projects were transmission lines, roads, railways, bridges, and caused fragmentation of the wildlife landscapes. And in that year, not a single proposal was rejected. Further, it was found that all these diversions, 40% were fragmenting wildlife corridors. From this, what can we conclude? I think we can safely conclude that it is human activities that are actually causing this sort of a conflict to take place and to exacerbate this conflict that is happening. And frankly, the wildlife is basically at the receiving end of our activities. So I'm just now going to describe two situations where human wildlife conflict is something that is happened and something that is unfolding. The first one I will describe is about an area in Kerala, in Munnar, where I was the DFO way back in 2001 to 2004. Now, at that point of time, there was a very beautiful area called Chinna Canal. And this Chinna Canal, if you go to the next slide, please. Can you just go to the next and the next one? Yeah, next one, please. Yeah. So if you look at it, this is the beautiful type of a terrain which was there. And if you see those mountains there, that is known as the Madikettan forest. And that is where the elephants would climb down from and come to this water body called Anairingal, and then climb up again and go to the other side of the hills and then come back. Can you go back those two slides? Yeah. One more. Yeah. So at this point of time, when I was the DFO there from 2001, in 2002, there was a proposal which was mooted that landless tribals will be assigned land. And they chose Chinna Canal as one of the areas to assign about 276 families to that area, comprising of some 600 hectares that would be settled there. Coming to know this, I immediately wrote and informed everyone this is a very perilous situation because this is a traditional migratory path of elephants. And as I showed you, they move down and have water, go up again. And that is a traditional route. They keep going up and down that way. And therefore, if you try to put up habitations there, this is what's going to happen, that you're going to block the migratory path, and who's going to suffer? It's going to be suffering on both sides. Both the wild elephants as well as the people are going to be bear the brunt of it. But you can well understand that it had no traction, and these people were moved there and they settled there. And as I said, I've shown it on the map. That is the Madikettan Shola. You can see it comes to Anairingal, and from there it goes to Chinna Canal and then goes across. Next. So these people, as I understand, that as soon as they were moved there and they settled there, within a year, this conflict escalated. And at that time, when I was the DFO, there was hardly any conflict because there was nothing that stopped the passage of these elephants. They would move coolly and come back. There was no conflict. But within a year, this conflict happened, and there was huge amount of, problems for both the elephants because they were not allowed to move, as well as the people who were staying there. After that, we found that most of the people actually who had money from this colony, it was called the 301 colony, they left and went away. Only 40 families who did not have the wherewithals were left there, and they continued bearing the brunt of the problem there. Besides this, let me also say that a huge, as it was so beautiful, I showed you that photograph, it was so beautiful, so many resorts came up. And along with these resorts, if you see the next slide, please, all these homestays also came up. So all you have is tourism infrastructure there, each one wanting to protect their property. They're having this huge, the tourism facilities, no doubt, but to save themselves from elephants, they have built these fences, electric fences, solar fences. Now, what does the elephant do? It comes there and it tries to cross, isn't able to, so there is conflict and it breaks down these, fences, etc. And next, please. So, next. Yeah, so this is what actually I'm showing a photograph that this is in the 301 colony. I had gone in 2017. I told you there were just some 40 families left. And there was an old lady staying here because she didn't have the means to move out. And she told me about this elephant Arikomban, which I showed in the beginning, that very robust elephant which was there. And Ari means rice and Komban means a tusker. So Arikomban was that elephant. And this lady, because of the house that she had constructed, you can see it's a single brick wall with just a pretense of some sort of a cementing outside. So the elephant would come, push open the wall and take out the raw rice and eat it and go away. And it did it so frequently. It did it all the time. So what happened is that there was naturally a lot of fear also, because it was not just the rice, but when a big tusker comes, what are the fear that it makes in another person. So from then on, that time itself, these people told me, please take us away from here. We can't stay. It's difficult to do. So there was only that much that we could address at that point of time. But in 2023, basically, in the beginning of 2022-23, this Arikomban started doing a lot of, increasing its raiding of rice, etc. And there was a hue and cry from not only the people from this 301 colony, but also from the resorts, mainly from the resorts, basically. And also you find that, and they wanted this Arikomban to be removed from there. So they asked the government to remove it. And at that point, I was the PCC. This is in the beginning of 2023, and running a program called the Rebuild Kerala Development Program, where we were taking care of relocation of people also who were willing and who were ready to move out. So we made a proposal to the government that would you like that we can, shift these people using this particular scheme, and they will benefit, and also we'll find that the migratory path will also get opened because of that. Do you know what is the message? And I put it in writing. I did not say it just like that. I had put it in writing. What was the response I got verbally? That no, please don't do it, because these people are buying the rations from the shops there. And if you move these people, these owners of the ration shops will suffer, and the small businesses will suffer, as well as the fact that these resorts which are there will not be able to get their labor. So we can't move them. So that was the reason given for not moving them. Besides that, till date, these people are still there. They have not been moved. And this conflict continues. What happened instead? That Arikomban was shifted and taken away, and he was transported to the Kanyakumari forest. Next. This is the sort I was telling you, the sort of damage. These are the electric fences, the solar fences that are there. This is the elephant must have come up and climbed onto this car, and this is the condition of the car after that. Okay, and this is all along, as I showed you that first map, there is one road which goes, which is actually having all these resort facilities, and which is actually crossing the path of the elephants. Next, please. So what happened in 2023? They loaded Arikomban and took him away, and he is no longer there. So now, have we solved the problem? Next. Now, Arikumban's place has been taken over by many other elephants. Now we have Padayappa, we have Chakkakomban, and what are they doing? Because now you see this fences there, they're coming there, and they are also getting misled because no longer is that path available. Now they find food in these dumps, in these, what do you call it, waste dumps, and fresh vegetables, etc. there. So what do? They are there, and now Arikomban is being taken over by many more. Okay, next please. And then I would like to just say one thing, that this area, if supposing we had taken action in 2001 and not relocated these people, think of what would have been the different situation. Secondly, also think about it, that this was the area that, as per the Godavarman order of 1996, it should have been identified as a forest and kept as such. If we had done it at that time, we would have kept the forestness of this area, this problem would not have happened. But that did not happen. This problem is there. So let us ask ourselves, who is actually responsible for this conflict? Is it the elephant? Or is it us, especially the policy makers, the governance, the bureaucrats, and that whole greed that is involved? So how and who is bearing the brunt? It is the elephants. They are absolutely reactive only to whatever we are giving to them. So that is one situation where I was saying where the conflict has actually happened, and there is a human wildlife conflict, and how many elephants are we going to remove? Now let me come to another story which is unfolding. Okay, this is right at our doorstep at Delhi. Now next please. Can you play the video? The sound please.
औसत सूचना पुलिस स्टेशन के नजदीक तेंदुआ आ चुका है। आप सभी अपने घरों के अंदर रहेंगे, कोई भी बाहर नहीं निकलेगा। किया जाता है पुलिस स्टेशन के नजदीक तेंदुआ आ चुका है, कोई भी घरों के बाहर नहीं निकलेगा, सभी घर के अंदर ही सुरक्षित रहेंगे। आप सभी को
So this is exactly what's happening right here, just beside Asola Bhati mines, and the wildlife sanctuary, which used to be a mine earlier, is just right next to Scenic Farms. And that particular area is having about 8 resident leopards. And one of the leopards chasing its prey, that is maybe a dog or whatever, came here, got confused and did not know how to go back. And this is what resulted. We saw how the terrible situation of the man being frightened, the leopard being frightened, and the announcements being made, all that happened. Now, just to look at it, actually, this is a part of a whole corridor from Sariska Tiger Reserve, going from Gurgaon to Nuh and coming up to the Asola Bhati. It is actually a 200-kilometer stretch, and the leopards move in this. Now, our next great plan is that we are going to make a safari park in this area. Okay, and this safari park is a larger part of that leopard corridor. Now, please think what is going to happen. We are very soon going to have that leopards coming into Scenic Farms and maybe ingressing further into Delhi may be a common occurrence. This sort. So, but what I wanted to say about that is, it's a question. Imagine how fearful it's going to be for the leopards, and what about the poor people there? How scared they're going to be. And therefore, if we continue with this situation of making this park and having this network of roads and tourism and the tourism infrastructure, all the waste that comes, can you imagine what's going to happen? So we are having a conflict in the making. It is up to us. Are we wise? Can we stop it? Will we stop it? If we stop it, we will not allow this to happen. If we don't stop it, we will have another Chinna Canal just a few years down the line. I was a DFO in 2001, 2002. This is in 2023 that this thing escalated, not even 20 years. Are we looking at this for Delhi? Is this what we are trying to envisage, that we'll have a leopard conflict going on at our doorstep? Next, please. I'll quickly finish it with 2-3 more points. Oh, not this one. Read next after that. Okay. All right. Leave it. Just go back to that one. So let me just say it by this way, that most people say that, oh, what's so great about wildlife? We human beings are more important. Let us kill them, decimate them, and finish them. And let us live, because we cannot have a nuisance. But the point which we are trying to, we must understand that there is something as the ripple effect or the trophic, ripples that happen. So anything that happens in one part of the food chain impacts another part of the food chain, which is called the trophic cascade effect. So you remove the predators, the herbivores will increase. If the herbivores increase, our agriculture gets impacted. You remove the herbivores, there is no prey left for the carnivores, so they will attack our livestock. So therefore, any change in any one trophic level is having a cascade effect. So that is one very important point, how we are impacted. Let me come to the next important point of this is that what we don't realize that something like that has actually happened. And something that has happened right now in our lifetime only, that there is a link between the vulture decimation and rabies increase. The vultures, they died, we know, somewhere in the 1990s to 2005 or so, due to diclofenac consumption. A lot of the vulture populations just collapsed. Once they collapsed, the feral dog population went up, and there is a correlation that this rabies also went up during that period. There is a correlation which has been seen that the sale of anti-rabies vaccine has increased during that period. And therefore, and why did that happen? Once the vulture population collapsed, all these carcasses of the livestock that were put in these dumps, the so-called graves or whatever, where the carcasses were dumped, the dogs came and ate it. And therefore, their population also increased. And because of that, the rabies also that spread was there. Besides that, the body of the carcass did not completely decompose. They were, it rotted, and it went into the water bodies. And once it went into the water bodies, there was disease, and human beings were impacted by it. And it was seen that in that period, there is a study which says that 5 lakh deaths occurred during that period because of this reason. And it was, if just calculating it in terms of money, it comes to be something like $70 billion that damage was done. So if we are not even looking at that, look at the economic loss that is there. So this is the next point that I wanted to make. And let us also remember that COVID is something that we are still trying to combat. It is a known zoonotic disease. What it did to us at every level, not a single family was left untouched by it. And are we not ready to understand and take, lessons from it? Are we ready to allow ourselves to go on that path again? That is another important thing. I would also just say one thing, that is what has given to the concept of One Health. So that means that every species and life forms in our environment is connected. So human life, wildlife, as well as the environment are connected, and therefore we have to look at it from one aspect of One Health. If we do that, probably there will be a better way of addressing the issue. And now I will end it by saying that there is a very remarkable book written by Jeremy Diamond. He wrote about, and the book's name is Collapse, How Societies Choose to Fail or Succeed. And what his take on that was that every society, he studied certain societies that were in historical societies, and found that there were 4 type of issues that every society try to combat or address. And these 4 things, he said, were influences of environmental change, climate change, hostile neighbors, and trading partners. And any society which succeeded, it depended how well they responded to these 4 stimuli. So if a society was able to change and take forward those particular behaviors that were positive and jettison those which were damaging to them, those were the societies that succeeded. And therefore, he said that that's another point that which he said, which is, I think, very important. And I'll just read that. It says, it can be especially bad when short-term interests of elite leaders conflict with long-term interests of society, and the elite are insulated from the direct consequences. So it is very important that our long-term planning should be good so that we can actually address these problems. And I'll end it by saying this only, that we are a society which has been, we revere our wildlife, and it is a part of our daily living. And we should really give credit to us also, that despite this huge population and these huge problems, we still have a wildlife, and a good viable one. We have not finished our carnivores, unlike certain other countries in this world. So let us go back to our roots. Let us ensure that we take them along. While our survival is important, so is theirs, and we take the right decisions. So we are at this stage, a threshold, that we can decide that do we want to succeed or do we want to fail? I hope we choose success. Thank you.
Do we have some time? Yeah, we can have a few questions or comments if anyone has. Yeah. Do we have the mic?
So it is not so much about the people. It is the people, as I said, there was a particular decision of the cabinet at the time that all land is private within and time. And therefore, it was not just Sinasana, so many parts of Kerala, they were right, right? And these people were said, if you get land, you go and live there. These people who went there were basically not very educated people, they were ready to do, and it was all, as you can understand, they were studying different, political reasons for moving. So these people very innocently went there and occupied that place. And as, just to bring to you another point, during that time only there was a family reserve, right? And that was a notified reserve. Despite that, the government moved the people there, the came there, so much so that the sisters came there and actually ensured that this whole land was distributed. And the forest officers were at the mercy and would believe the situation that none of us went for the program. We said it may be possible that it is the chief minister's program, but this is not done. There are reserve forests is being distributed, but it's not. And what do we do? So this is the proper thing that happens. And something else like that Madhikatam, which I showed, that photograph and the map, that also, in fact, they were saying that they went and completely colonized. They had made, areas which were, and they had different political parties. And the whole area they had taken over. And then at that time, in the got a complaint because it was so early event and entered this whole area, that Madhikatam, we not only existed, after that, we ensured it came back to the cloud and it was notified as a national Madhikatam. So basically, what I was trying to get at, it was not a people-driven thing. It was the political and the bureaucratic-driven move that we made, which resulted in this. And also to add to that, there have been many meetings after that. That how to actually, take back this area and to ensure that the migratory part is again restored. But again, that decision has not seen the light of the day. It still is on paper, and probably the money involved, and more than that, that there are too many pressure groups involved that they will not actually most of the proposal in 2010. So how to actually do that? So that's the matter. You have questions?
There's a mic ready.
around the world. At all the group was needed in the room. I want to request you, invite you to please join hands and let's make this a reality. We have 5 years to come. That this A Tree for Every Human project will also lead to many other projects around the world, and we will be able to mitigate climate change. Now, I shared that this was started in 2023, but then it's been delayed. It's been delayed because I got involved in advocacy work in the Supreme Court. And I want to share that how the Supreme Court has turned into not the Supreme Court of India anymore. It's the Supreme Court of probably the government of India, or the Supreme Court of Bharatiya Janata Party. I got involved in a couple of litigations, especially related to Manipur, and we saw that how thousands of weapons, thousands of bombs, and lakhs of bullets have been handed over, and it has led to a carnage. The court has delayed the matter so much that in the last 2 years, only one date has happened, which has effectively now made the Geeta Mittal Committee appointed by the court itself to go defunct. So the reason I bring this up is that Sir had said that we need to replace our politicians. Sir, we need a systemic change. We need to replace the politicians. We need to replace the bureaucracy. We need to replace the judiciary. It's a cancerous tree and it needs to be uprooted, and a new tree has to be planted. I invite you to please join hands regarding that as well. And finally, where is the actual root of all of this problem is because we have an unelected government in place today. 538 constituencies in the last election did not match the number of votes polled with votes counted, and the unelected government is wreaking carnage in the country. That's the reason why I started a campaign also called A Second Independence. I'm a grandson of a freedom fighter. On 13th April this year, I started a movement called Dusri Azadi Ki Muhim. On Constitution Day this month, 26th November, I am calling for nationwide protests against a government which is unconstitutionally in place. And that's the only solution for long-term sustenance of our country and the world.
Very questions to the panelists on the.
Good evening, everyone. So my question is to A.K. Jha sir, and so from your talk, I could gather that some of the political leaders, for their political advantage, are giving out the forest lands to the individuals. But then I have also been to a few tribal communities. There's one in Jhabua, and I've also talked to the CSOs operating out of Gadchiroli, and I've seen that when the tribal community gets the community rights over the forest, they're able to restore the forest well because their livelihood, they have a stake. If the forests are healthy, their agriculture is healthy, their livelihood is healthy. Many villages have returned back from the cities where they're working as laborers back to the villages because now they can manage the forest well and hence take care of the agriculture. So have you also come across cases where the community has actually destroyed the forest after taking the control over?
Yeah, thank you for the question. Actually, one point I would like to make clear that FRA in itself is not bad. Its implementation has been terrible. Okay. So it's good to give them rights. But then who controls it is the matter. Now in Gadchiroli itself, the best example that is quoted all over India today, or maybe all over the world, is the Lekha Benda of Gadchiroli, right? That is one village where I was DFO Gadchiroli in 1991, right? That time they were just coming up. So they got the community rights 3 times. First, they got the community rights along with the right to hunt wildlife. Then it was modified. in 3 years' time, then it was given that whatever they had been doing earlier, if the management was being done, management is being given. Again, that was found to be not correct. So third time again, the third order that you see is totally, irrelevant in fact. It doesn't really speak anything. It just says 3(1)(I) is given, rather that particular right is being given under the particular section. That's all. Nothing beyond that. Now, well, because of the pressure, public has a lot of pressure. So because of the pressure, they continued with the working of that area. And in the first year itself, in 2012, they clear-felled the bamboo areas. All the bamboo areas they have clear-felled. Why? Because they wanted all the money as early as possible into the panchayat or maybe Gram Sabha account. Otherwise, actually, they should have gone for a bamboo working system, which is very specific, which gives you bamboos every 4th year. It's a sustainable system of management of bamboo forest. That was totally sidetracked. They got about more than 76 lakhs or something. They were very big leaders. They came, even the previous forest minister, he went there, gave a transit permit book to them and said that now you are independent of the forest department. Azadi mil gayi. That was what was this statement given by the previous forest minister at that place. So people were very jubilant, and in their jubilancy, they spoiled the forest. And even today, there is no bamboo coming from that area. Now I'll give you the real problem in the on the ground. They have got dependence on the bamboo for their hut repairs, for their village boundary repairs, etc., etc. Last 4 years, after 2012, they are not able to get anything from their own area, which was actually their right. What are they doing? People are going and stealing from the nearby villages, and there are conflicts. And these other villages, people also, they also are stealing from some other areas. And they were so jubilant, they came to me also, sir, we are independent of you. I said, wonderful. What will you do tomorrow if there is a bamboo flowering? Today, the forest department is giving you bamboo from Wardha to Gadchiroli, Gadchiroli to Chandrapur, Chandrapur to Nagpur, Nagpur to Amravati by trucks, because you are dependent on them. Tomorrow, what will you do? Will you purchase the bamboo from somewhere else, and will you be able to supply it to every right holder? No, sir, we never thought like this. So it's very nice to think of an island within the country, within the forest area, an island of a forest village. And you know, under FRA, every hamlet can be declared as a village. Is a hamlet sustainable in any way? So this is all farce. That is the biggest problem. We can't really become independent of everything around us. That is what was tried in Lekha Menda, the best cited example in all the documents in India on NGOs and on CFRR. And that has failed. This is just one example. Another is, there are a number of examples. But I'll be very happy if there are villages or villagers who want to sustain on the forest, want to do good to the forest and sustain their lives. I'll be very happy if that happens. That eases the department's headache also.
Thank you. Thank you very much. I'm sorry, I'm sure there are many more questions, but because of the shortage of time, I'm having to guillotine this event. I really want to thank the speakers.
No, one small point. I'm so sorry.
I think maybe
about Tendu Patta trade, you know, new traders have come. The NGOs have become contractors. What is this, yeah?
I think maybe we can discuss it during the tea.
Yeah, sure.
I wanted to just thank all the speakers. As was said, this has been truly a 5-star event in terms of just the knowledge. It's been a scintillating afternoon. You've been so well informed, and I hope you've been able to translate some of this to some of us. We have certainly benefited greatly. I'm extremely grateful to all of you. And on behalf of CCG, I invite you all to carry this on and share a cup of tea with us. Thank you. Thank you. Thank you so much for coming. Thank you. It's quite a long